Any mention?
Lordship, item was 16 and 17. I need only 2 weeks time only. I'll just take instructions from the client and just take in concern.
Become a sad story now.
Sad story.
Why? You need material instructions or?
Material, I think. That's why I'm laughing.
No, Mr. Mitchell's now.
Okay, if you need material instructions, court understands.
Instruction only just to whether either to pursue or withdraw or to go to file appeal.
1 week.
After 1 week, Lordship.
1 week.
One week.
After 1 week. No point. Is
Yes.
patient already on ventilator.
Ventilator, yes.
That's all.
He's planning to go to PD, I think.
Huh?
He's planning to go appeal.
Yes,
You go appeal. Yes, you appeal.
yes. We are planning to.
Before the contempt board only.
No. Now it is a principal director's.
Principal director.
For the different estates.
Yes.
Better prefer appeal. Why not?
Yes.
Provision is there.
Yes. After a week, Lordship, I'll just take instruction.
Yes.
Deputy Office.
May I please, Your Lordship?
Yes, Mr.
I would
Chanda.
like to, yes, Your Lordship. I would
Yes.
like to mention item number 31 of the daily first list, Your Lordship. Hearing matter, Your Lordship. I'm seeking adjournment on item number 31.
2 weeks, okay? 2 weeks.
2 weeks, Your Lordship.
Yes.
Your Lordship.
Yes, Mr. Parson.
Obliged.
Please, Your Lordship. Your Lordship, I beg to mention item number 29, Your Lordship.
Yes.
I pray if this matter can be taken up after 2 weeks, Your Lordship.
What's the matter about?
It's a promotion matter, Your Lordship.
No urgency.
He retired, Your Lordship.
Very tired.
Lordship, yes.
After 2 weeks, yes.
2 weeks.
I do.
Obliged, Your Lord.
Please, Your Lordship, I
Yes.
beg to mention item 32.
32. 30?
32.
Capital enterprise.
Yes, Lordship. I'm praying for
Yes.
2 weeks' time.
No objection. Yes. When?
After 2 weeks, Your Lordship.
2 weeks, okay, yes.
You oblige.
May please, Lordship, I beg to mention item 18, Your Lordship.
Number?
18, 1-8. Lordship, here the paper book is not yet ready, so I pray for 4
What
weeks.
paper book?
Paper book.
For petitioner.
Yeah.
18.
18.
Anjali Nangrum.
Yes, Your Lordship.
Is it connected with 20, 19?
No, Your Lordship.
Okay. No, the paper books are ready. Why make paper
No,
books connected?
it's-
Anyway. How much time you want? 1 week?
4 weeks, Your Lordship.
4 weeks, why?
Lordship, paper book, it will take time, Your Lordship, to prepare that.
3 weeks, okay. To enable the appellant to prepare a paper book. Yes.
Lordship, I pray for item 26. Lordship, let this matter maybe come up after 10 June, Your Lordship. The conducting counsel, senior counsel,
Yeah.
it's
Nothing to say, Your Lordship. We were supposed to get some case laws on the powers of the
Yes.
DPC, Your Lordship.
Okay, 2 weeks. Yes.
I'm ready, actually.
After 10.
similar items for item 27, Your Lordship.
And for the state responders only.
Correspondent number 2, Lordship.
Okay, 2 weeks, yes.
Highly obliged.
May it please, Your Lordship. Your Lordship, I beg to mention item number 21, Your Lordship.
20?
21, Your Lordship. I can pray for 2 weeks' time, Your Lordship.
Twenty-one.
Yes,
Ever will
Lordship.
channel inquiry.
Yes, Your Lordship.
Other side is whom?
I have informed Your Lordship.
Who's the other side? You inform them. Seri no country. So many S.E. Sheikh, Ailingwa, Khan, S. Sen, H. Abraham. Who's the parents matter?
Your Lordship, I'll inquire, Your Lordship. No objection, I'll inform the council, Your
1
Lordship.
week, yes.
Deeply obliged.
Your Lordship, I beg to mention numbers 19 and 20, Your Lordship.
19 and?
19 and 20.
Your seniors come back?
No, he's still under treatment, Your Lordship.
Yes, sir. After 3 weeks, yes.
But item number 32 was mentioned, my lord. Well, this is a tender matter.
32 is a?
For borewell, my lord. Well, here what happened, my lord, because of the pendency, though there is no stay order, we have not been able to proceed with the work, my lord.
Which borewell?
In the BSF, my lord.
Yes.
The matter is called out, so some kind of liberty is granted to us to proceed, my lord.
You asked your senior? Then why did you object to it then, that time?
They didn't inform me, my lord. Kindly, my lord, the matter is called up.
I'll inform my senior.
Yes.
May I please, Your Lordship?
Yes.
I beg to mention item number 22, Lordship.
Fernandez.
Yes, Lordship. After 1 week, Lordship, due to personal difficulties, Lordship.
1 week, yes.
Highly obvious, Lordship. Right, Lordship. Please, Your Lordship. Your Lordship, I beg to mention item 15.
15?
15, Your Lordship, of the hearing list.
Marvin Enterprise. Yes.
Your Lordship, Mr. Paul is having...
Yes.
Mr.
What
Paul
happened?
is having some personal difficulty.
Yes, Mr. Sai. No objection?
No objection, Your Lordship. Otherwise, the rate is not maintainable. It's a contractual dispute and they are asking for relief of a pecuniary sum by way of a mandamus.
That's for all amounts.
All amounts, Your Lordship.
How long?
1 crore 8 odd lakhs
after
by
a
way
week.
of a mandamus.
Okay, 1 week, yes.
As well.
Highly obliged.
Wait.
Lordship, I beg to mention item number 24. The conducting counsel is indisposed, so two weeks' time may be allowed, Your Lordship.
Correct, counsel is Mr. Joshi.
Shantanu.
Okay.
Right,
1
sir.
week. Election petition?
Yes, Your Lordship.
You make an application?
Already filed, Your Lordship.
Yes. Adjourn for 1 week?
2 weeks, Your Lordship.
2 weeks, yes. Okay.
Much obliged.
Yes.
Supplementary list, item number 1.
Wait, please, Your Lordship. Lordship, I apologize in advance if I sound a little hoarse. I'll try my best to make the submissions properly.
Sound a little hoarse?
Hoarse, my lord. I'm
Oh.
having a throat problem.
It's all right. Yes.
Lordship, this
Who filed as caveat?
caveat was by...
Caveat.
It has been served, my lord.
That may be the charge. Yes, take down please. Caveat number 4020. Stop. See in the caveat petition, filed by, this is respondent number, you're the?
In item number 1, my lord, he is respondent number 1.
No, I'll just take the name. By the, see in the caveat petition filed by caveator, namely one Srimati Nazila Begum, who represented by Mr. S.D. Sub caveat stands as charge, yes.
In item number 2, he is respondent number 4.
Doesn't matter. And both, all whatever caveats are there. Or you file 3 caveats? No, ma'am, 2 caveats.
2 caveats, separate persons.
And next one, which person is that?
Shobza Begum, respondent number 4.
The next one, Shobza Begum. But hasn't been, yes. Review petition.
Yes, my lord. Review petition, my lord. Your
Why?
lordship will recollect. My lord, if I may take your lordship to page 31 of
What
the...
matter is this?
My lord, that Khitadhoa LP school, your lordship had directed inquiry by the Commissioner Secretary Education Department.
Okay, yes.
Yes, my lord. If I may take your lordship to page 31 of the review petition, my lord.
31?
Page 31 of the review petition. That is the
What ground is just
judgment.
tell the court?
Yes, my lord.
On what ground is seeing review?
Yes, my lord. On the basis of this, I will show to your lordship how...
Why? What is the ground for review?
My
You
lord-
know that review jurisdiction
Yes,
is
my
very,
lord.
very
It is
limited.
if there is any error apparent on the face of the record, I
So
can
what
show
happened?
that.
Have
my
you
lord.
filed appeal?
Yes, my lord. I had preferred
What
an
happened to
appeal.
the appeal?
My lord, in the appeal, I had not pressed on the merits of the matter. The main question on which the appeal has been disposed of, the ground that I had raised before the Honorable Division Bench was non-furnishing of inquiry report. So the learned
What
division,
inquiry report?
The inquiry report, my lord, which was submitted by the Commissioner and Secretary.
But that's not a departmental inquiry report that they
My
were
lord,
given.
that is the same.
That is
My lord,
inquiry.
that is,
it was directed by the court.
My lord, that is the same finding given by the learned division bench as well.
Bench?
At
page
number.
Before my lord,
At page 37.
Challenging the maintainability of the review petition, my lord. If my lord may kindly come to page 38, my lord.
Yes.
7, my lord.
Yes.
In view of the above aforesaid submission, permission is granted, and so and so are dismissed as withdrawn by giving liberty to the appellant to approach to the learned single judge by way of filing review petition. It is so advisable.
If so advised.
Yes. If any such petitions are filed, it is for the learned single judge to decide the issue with regard to the plea made by the learned counsel for the appellant, including the maintainability of the review petition in accordance with law. It is made clear that the period during which the writ appeal are pending may be excluded. Now, my lord, the term which has been used by the division bench is maybe, my lord. There is no delay continuation application, my lord.
My lord, I can explain that.
There is no delay application.
My lord, I can explain. My lord, the delay condonation petition was sent since the computation itself has been removed. My lord,
you have heard of the term. Have you heard of the term abundant caution? What is abundant caution?
My lord,
What do you mean by abundant caution?
My lord, in the registry.
What is abundant caution?
My lord, that the appeal period may also be included in the petition.
Abundant caution is when a matter is filed, an appeal is filed within a certain stipulated time.
My lord. And
other intervening reasons are there,
my lord,
which will into consideration will make your appeal, maintainable within the limitation period. Now, an application is filed for condoning the period of delay, if any, by way of abundant caution. That's what it goes. So the court can examine whether the appellant or the review petitioner had taken enough care and diligence to see that that they have pursued other remedies. That's when then we'll reject it.
My lord, will kindly grant me
orders dated when?
My lord, this order is 24/11. And then on 8/12, I had filed the appeal, my lord. That was a period of 13 days.
That you have to explain by Miss Case.
My lord, I may be permitted within 2 days, my lord. I'll file it. It's ready. It's absolutely ready. Just the number of days needs to be filled, my lord. Everything is ready.
This has to be withdrawn, my lord, and then
my lord, in this particular review petition itself, I may be permitted to file a miscase, my lord. That was done previously also by the learned
division. Has to come, my lord. Then only my lord may.
Yes. Then only review petition can be registered.
My lord,
registry. So how come they registered the review petition? But the order is dated. When's the order of?
My lord, this honourable court. My lord, this honourable court had passed the order, the judgment on 24/11.
24/11.
The appeal.
Very good. Now that has to come by an application.
My lord.
It can't come by way of oral submissions.
Yes, my lord. I'll do that.
You don't. What
it is already written in the petition.
High Court is a court of what?
My lord, it is a court of record. Court of record.
Then, as a court of record.
Lord, that is why I may be permitted to file the miscase in this itself.
Then because my lord, deregister review matters. The review petitions.
Earlier also in the appeal it was permitted during the COVID times, my lord. In the writ appeal also it was permitted once, my lord.
COVID time means what? It's the order of Supreme Court.
My lord, but still I was told to file a condonation petition, my lord, after registering the writ appeal.
We don't want to, to relegate you to applying flat copy again. But anyway, you make an application to allow you first.
Deeply obliged, my lord.
Yes.
Obliged a lot.
It is noted that the review application have been filed against an order dated
24/11/2023.
2023. Stop there. There is no accompanying condonation application showing sufficient cause for the delay. Stop. Petitioner, counsel petitioner have a praise that should be allowed to file an application seeking condonation. Praise allowed, yes.
Deeply obliged.
Obliged, Lord. 1, 2, 3.
1, 2, and 3, my lord.
I mean, at least he pointed it out. I thought that it was.
Daily list, item number 1.
Sorry, yes.
Your Lordship, I'm praying for some accommodation for today.
For the day?
For today. I'm bringing subject to your Lordship convenience. I think this
Contempt?
matter may come tomorrow.
He's not there. What's it come for today? It's for admission hearing.
Admission hearing, Lordship.
Where's Mr. Changreso? He's out station.
Lordship, he's occupied in courtroom number 4 in one part and matter. I'm bringing this matter may come tomorrow, subject to your Lordship convenience.
No, tomorrow, come next week.
Have you pledged?
Yes, due to unavailability of the Senate Senior Arguing Counsel at the moment, this is matter on Monday for admission hearings.
Shall you pledge?
Item number 2.
But I am required to file an affidavit, my lord. I have received instruction, my lord. I have drafted. In fact, I can serve him a soft copy today itself, my lord. But filing, I may be granted 1 week's time, my lord. This has come from Guwahati, my lord. But soft copy, I will serve him today, my lord.
Yes.
No objection, Your Lordship.
No, have you filed the rejoinder to
No, Your Lordship. I pray for another.
You filed it?
I pray for another 2 weeks' time, Your Lordship.
Why?
Certain documents which have to be annexed, we're not getting it.
Mozika submits that due to unavoidable reasons, the affidavit as allowed to be filed by Order 34/2024 cannot be filed within, it has not been filed as yet. Whoever submits that copy of the same will be served on the counsel petitioner today. Mr. Elsa Lasang lawyer, counsel petitioner also prays that he be allowed further
2 weeks' time, Your
2
Lordship.
weeks time for rejoinder to the affidavit filed by the state respondent. But in consideration thereof, this is matter after 2 weeks for the orders.
And item 4, Your Lordship. Item 4 also
Same order.
Same order. Obliged.
Obliged.
Item number 3.
Not interested anymore.
Lordship, actually, Mr. Paul was supposed to be here, but
No, we can't keep on adjourning these matters like this now. They're stuck on 711 petition. You tell your senior. Also, if they're not interested, the election petitioner, why burden a docket report?
one more.
Once election gets over, that fire is there that I've been wrong, file election petition. 1 year goes by. Mr. Kinjing knows that very well. Right, Mr. Kinjing? You know it very well. When they lose, they feel that there's been a lot of harm been done to them, file election petition. After 1 year, everything becomes cool. How long? 3 weeks? For the exhibition. For the reason stated in 30 weeks, yes.
Item number 5.
Lordship, we're supposed to file a rejoinder affidavit, but we could not file, Lordship. The petitioner is from Garo Hills, so I pray for 2 weeks' time, Lordship.
How many times you prayed for rejoinder?
This is the first time, Lordship.
Okay. For the 2 weeks' time, as prayed aloud for rejoinder is just that after answer.
Item number 6.
Please, Your Lordship. Lordship, I seek some time to file my rejoinder, Your Lordship.
How many times you prayed?
This is the second time.
Okay. For the 2 weeks' time, as prayed aloud for rejoinder.
Item number 7.
Please, Your Lordship. Your Lordship, I've just received the information from the petitioner yesterday, Your Lordship. I'll file it by tomorrow, Your Lordship. I pray the matter may be listed on Friday.
Well, it's on Monday. MS PS Nambri submits the necessary materials have just been received. Instructions were received. She prays aloud 2 days' time to file affidavit.
In this matter, earlier an interim order was passed, my lord.
Yes, Your Lordship.
And there was certain non-compliance on our part. Now what has happened, my lord, the things as it is turned out, there might be some vacancies, my lord. So we will take care of that.
We'll take the case as it comes. Any further instruction that they'll file the affidavit first. This is next week.
I'll oblige, Lordship.
Item number 8.
Please, Lordship. Lordship, I have received the affidavit of an opposition just yesterday, Lordship. Kindly give me some time to seek instruction, Lordship.
Who?
Kindly give me.
Instructions?
Yes, Lordship.
Council petitioner praise funds allowed. 2 weeks time to seek instructions whether rejoinder is necessary or not. That's the last for the orders. If not necessary, we'll post it for hearing.
My Lord, the prayer was to conduct fresh election. We have given documents that it has already been constituted last year in December.
Let them take instructions, yes.
I'll seek instructions.
Item number 9.
Much obliged.
I'm praying for further 2 weeks to file my affidavit on behalf of respondent 1, 2, and 3.
Have you obtained status of service on respondent before?
My Lord, regarding with this, I have sent letter to Senior Superintendent of Post Office, but the letter not yet received.
Yes, your name?
Kelly Tap.
Yes, MS Kelly Tap for the petitioner submits that status of service from respondent before has not yet been received. She prays for allowed further 1 week's time to obtain the same.
I'm praying for 2 weeks for filing affidavit.
Why 2 weeks?
Just received the instructions, Lordship.
Okay, I wait 2 weeks to same. Mr. S. Deb, on behalf of respondent 3, also prays for further time.
Respondent 1, 2, and 3.
This after 2 weeks.
Item number 10.
May it please your Lordship. Lordship, I'm praying for some more time to file our counter affidavit. I'm representing respondent number 6.
Respondent for 1 to 4, Lordship.
Will not be filing affidavit.
Lordship, will be filing, Lordship.
Do you filing? 1 to 5.
Lordship, number 5 has is a tribunal, Lordship. HADC.
Tribunal? Does it stock off?
Yes, Your Lordship.
Oh, yes, yes. MS Sinon Club 1 to 4 and MS Cruz for 6. Pray for allowed further. No objection. 2 weeks time to file affidavits. Just thereafter.
11.
We have received the records now.
Yes?
We have received the records in as per the last
Yes.
order.
But the records are produced today. What's the matter about?
Your Lordship, this matter relates to
mutation,
and revenue matter, and we were agreed by the order of the Chief Executive Member, whereas Executive Member's order was in our favor, which was set aside by the Chief Executive Member on the ground that it's barred by limitation. But that period...
Why does the court ask for records?
Lordship, what had happened here is their contention is that the respondent 3 and 4 are non-tribals, so they cannot hold any land.
Oh, is that case of this petitioner filing case of own daughters?
Yes. So the EM has decided in their favor, saying that being non-tribals they cannot hold the land, but CEM has
overturned it.
Yes. So interim order is there in favor of them, Lord.
When will you file affidavit? You are paying for the daughters, both of them. When will you file affidavit? Within 2 weeks, positively. Now come 4 weeks. No, you be sure, otherwise you can't just give time. Anyway, Mr. Pasanthi, who is representing the response 3 and 4 praise, 4 ones allowed 2 weeks time to file affidavit. You file it and then Mr. S. Deb submits the records have been received. It's a matter for 2 weeks. Interim order shall continue. Ms. S. Deb to retain the records in the meanwhile.
Whether he will file some affidavit?
Will you file affidavit?
I'll file an affidavit.
Yes, retain records. He is also permitted to file affidavit.
Yes.
I'll file affidavit within the same time.
Item number 12.
Yes.
May I please, Lordship? I pray for 3 weeks' time, Lordship, to file affidavit. For respondent number 5. Lordship, as the documents required to be annexed are from Garu Hills.
Yes.
No objection, yeah.
Here for number 5.
Yes, Lordship.
1, 2, 3, 4 is not necessary. 4 is expired. No, successor wife only. Yes. Council respondent prays for not further. How much time?
3 weeks' time.
3 weeks time to file affidavits. List thereafter.
Lordship.
13.
This matter, my lord, we're faced with a small difficulty. The petitioner is a company based in Madhya Pradesh.
What instructions you're supposed to receive?
Yes, it's a tender matter regarding this MECL construction of the substation, 33 kV substations.
Yes.
Now they cancelled my contract and they floated a fresh tender. So, but it seems there's a slight confusion whether the petitioner has participated in the fresh tender. Then probably the matter will. But the difficulty is that the phone number is not. We are unable to contact, my lord. That is the.
So you took a brief and valuable matter just like that.
The number which was given to us is not in service. Or there's some difficulty. We are trying to contact by email and so on. Kindly give us some time, my lord. We'll try to.
So your client's blocked your number?
No, it seems he has some problem with his SIM card. Unable to contact, my lord. It's quite
They're not interested in this matter then?
Kindly have it next week or in 10 days, my lord. We'll take positive instruction.
Also, may I have it after 3 weeks, Lordship?
Yes. Mr. S. Deb submits that he has been unable to contact the petitioner to obtain instructions as was allowed by this court by order dated 7/5/2024. He prays for and allowed further 3 weeks' time to come up with specific instructions. That means not interested anymore. They didn't take part.
He's interested, but I don't know, maybe some
14.
problem with the communication. SIM card problem. I'll try to get it for the next week.
Obliged.
Please, Lordship, the respondents state they're supposed to file affidavit.
Yes, what's the matter about?
Praying for some more time, Your Lordship. This is suspension matter, Your Lordship.
Suspension matter?
Yes, Your Lordship. No disciplinary proceeding was conducted.
When was he suspended?
On 10 January 22, Your Lordship. 10 April 2022. Page 17, Your Lordship.
Yes. Why no instructions?
Your Lordship, we're still waiting for instructions.
Why waiting? Who's the officer concerned?
Your Lordship,
We'll
it's the
record that,
veterinary department.
record that you've not been able, that the concerned G has not been
some
obtained
time,
instructions. We'll ask him to come here.
Your Lordship, just a little bit of time, Your Lordship, is required. We'll be filing our
This is not the way. If a person is suspended for 2 years without information and without the department proceeding being drawn up, this attitude, that means that's why the department means nothing.
We'll get instructions, Your Lordship.
No. You get it by Friday. MS Eiling want to obtain instructions possibly by Friday, failing which officer concerned to appear in person. Yes.
Obliged, Lordship.
Copy of the order will be given to the learned GA. Yes. You can't have this attitude.
Hearing supplementary list, item number 4.
Paper book. Mr. Jindal, you said that all the entire evidence is contained in these paper books only.
No.
It will be common to all the depositions of all the claimants.
Yes.
It's all contained in one place.
Yes, Lordship. So far the common witnesses are concerned. Actually, issue involved, there are only 2 issues here, Lordship, basically.
No, that's all right, but I'm saying that it's all the evidence contained in one paper book.
One paper
don't
book.
have to go helter-skelter.
No, so far I am concerned, these all are contained in one small paper book.
And I will be referring for the purpose of my argument on paper book number 1, which I have submitted, my lords.
That thick one?
Yes, Lord. There are 3 volumes. I'll refer to volume 1.
This is other volumes.
This
This
prepared
is
by my learned
submitted by
senior.
me.
This has the
This is
evidence.
additional paper book.
Additional paper.
Yes, Lordship. This has the evidence. The notifications, the pleadings, the statements, the claim applications are all in the other 3 paper books.
Okay. 3 paper book you have submitted. This is number 1.
This is number 1. For today, I'll refer to number 1.
Yes. Number 2, number 3.
Lordship.
Very good.
Before I start, my lords, lordships will recall in this application, I had filed a single appeal. It was a composite appeal challenging several decrees.
Yes.
So against the award of compensation, Lordship.
I think I'll need a kata for this case to make notes. Not because these papers they fly all over the place.
Today is possibly only the introductory hearing.
How long will it take?
I'll just confine myself to 4 points, my lord, for today, because there is a cross appeal which I'll also address later, and then there are 4 independent appeals which are filed by the
introductory hearing.
So there are several points I need to touch. I'll just touch upon 4 points today, my lords.
Okay.
So, if lordships will recall, we had filed a single appeal against a common judgment which affected about 60 plus claimants.
Yes.
And there were multiple decrees which were prepared by the learned trial court. Upon our filing of the composite appeal, my learned senior had raised an objection with regard to maintainability on the ground that a composite appeal is not maintainable. That issue, while it was pending, by an order on the 21st of June 22, it had been recorded that the question of maintainability will be kept open to be decided at a later stage. In fact, on the last week, my learned senior informed me that he is not pressing the issue of maintainability any further.
Okay.
So I'll just go into the merits.
Very
and
good.
that issue becomes diluted.
That you agreed.
Your Lordship, later on I corrected myself. I said that that petition, Your Lordship, contains number of the points on the ground on which I have challenged the maintainability. Most of the grounds have become infractious because the stay is granted, delay is condoned. So only 2 points which are relevant are left out. After my learned friend finished.
2 points have been left out for the maintainability issue.
Maintainability.
On which are the
first point is that whether there can be one appeal when there are several decrees separately passed.
Okay, technical
and separate
technical
claim.
objection.
And second point is that that this is an appeal only against the order and judgment. So there is no appeal against the decrees.
No, I think that was amended. If lordships recall, I filed an amendment application that was
No,
already
no,
amended.
done, Mr. Jindal. Decrees were filed later on.
Yes, yes. Amended application was filed.
I'm sorry, Your Lordship, it slipped.
So if
Then
we
only
take
1
objection
point
with
left.
regard to one appeal against many.
That point, Your Lordship, I will just.
Yes.
So, as per my learned senior, what only remains on the preliminary point is the question of the composite appeal.
Okay.
In my respectful submission, that stands diluted in view of their cross appeal. Their cross appeal is similarly placed. 47 claimants have filed a single appeal against their individual decrees.
Yes.
So there can't be a different yardstick for the collector and a different yardstick for the claimants, my lord.
Yes.
So I think that entire objection stands diluted by their very own action.
Right.
So before I go into those first 4 points, my lord, I'll just take lordships to the short facts of the case. Now, with the intention to acquire land on either side of the Lad Umbroi Boirembong Road for expansion and construction of a national highway connecting NH40 and NH44, the government intended to acquire some amount of land. The total area is roughly about 2,80,556.11 square meters. So sometime 2,80,556.11 square meters.
Okay.
This is sought to be acquired. So a notification under Section 4 was published in 2011 under Section 4, 2001 under Section 4.
Yes.
Objections were invited. series of objections were filed as to the reason why there is no public purpose and so on. Ultimately, there was a declaration published under Section 9 on several issues. They came before this Honorable High Court.
Yes.
Certain directions were passed, they went back. Eventually, awards were published in July 2003. Aggrieved by these awards, they filed an application under Section 18 seeking reference. This reference petition was filed sometime in September 2003 in representative capacity. All the claimants appointed Armstrong CM to file the reference on their behalf. So it was filed in 2003. The reference order was passed in August 2003 and a case was registered before the judicial officer in Shillong. Now in that case, notice was issued to about 68 claimants, of whom everybody appeared barring 5 claimants. The state was issued, the collector was issued notice, but collector did not appear. Matter proceeded ex parte. The ex parte order was subsequently vacated sometime in 2005 with the direction that the collector could participate in the proceedings as well as the evidence, but could not file his written statement. So we are in a situation where there was no written statement filed by the collector. Thereafter, there were certain orders passed causing demarcation of the property which was acquired, and that was also allowed. Sometime in 2012, the claimants completed their evidence, and subsequently, because of the constitution of the special judicial officer in Nongpo, the case records were transferred. This was in 2015. The case was re-registered in Nongpo. Well, the collector's evidence was closed in 2015. There again, they filed another review. Again, they did not produce any witnesses or evidence. As such, today what we have is no written statement and no evidence on the part of the collector. It's only on the basis of the claim petition, the reference order, and the evidence of the claimants.
There is no written statement, there is no evidence tendered by the
nothing was
collector at all.
At all.
So in support of the collector, there's no evidence at all.
Nothing.
All the evidence is purely of the claimants.
Purely of the
and supporting documents that they might have adduced.
And just to point out, in fact, what they are seeking enhancement on is the basis of 3 sale deeds. These are dulies which are not registered. That's on the basis of which they are seeking that comparable rates should be paid. So that is the nature of the evidence they brought. Several other evidences on the question of the rates of the fruits and so on. As thereafter, what is also relevant is in March 2017, both the parties filed their respective written arguments, and the case was ready for hearing. The case was heard and fixed for judgment in May 2017. So from 17 onwards, the matter was already heard by different presiding officers, but for some reason or the other, judgment could not be rendered. Ultimately, the case was heard sometime in December 2019, and judgment was rendered in 17th of March 2020, just before the lockdown was announced. Now, the reasoning that has been assigned by the learned trial court for granting higher compensation in respect of the lands is similar to all the claimants, from what I have understood. And my lords, to establish that the reasoning on not just the question of enhanced compensation, but on the grant of solatium as well as the interest is prima facie erroneous, I will confine myself to 4 points today, my lord.
Okay. Your introductory hearing on 4 points.
4 points today.
Point number 1.
Point number 1, my lord, that court has granted maximum compensation for the lands without assigning any reason whatsoever. And the reason is erroneous. In fact, in their cross appeal, the claimants also claim that the reasoning adopted by the learned trial court is erroneous.
Cross appeals in all the references.
There are 47 claimants who have joined the cross appeal, and one of the grounds that they have taken is the reasoning adopted by the learned trial court for granting the enhanced compensation. They are not happy with the quantum. They wanted compensation based on the excess compensation based on the dulies that they had placed before the court.
Okay.
The court did not look at those dulies.
Okay, the first point, maximum compensation awarded without...
Yes. So what has happened, my lords? So there was classification of land based on homestead, quarries, arable land and so on. And what the court has done has looked at the classification of the rates and said that some people have been granted 60 rupees, some have been granted 80, some 100, some 120, and some 160. And court said, I don't understand why this discrimination has happened, so therefore I'll grant everybody 160, the maximum compensation. But there was no reasoning, and that is the only reasoning, parity, to secure parity, that's all. To establish this, my lord, I'll just take lordships to my paper.
Second point?
The second point, my lord.
Just give the broad, bird's eye view
I'll just
first.
take note of the broad 4 points.
Yes.
Court has granted solatium on the entire amount well, it's, Section 23 of the Act lays down that compensation which is granted, the expression compensation includes the enhancement on the area of the land, the market value that is. Then the rest is based on damages, on loss of crops, on fruit-bearing trees and so on loss of buildings, loss of employment and so on. So Section 23 comprises of various heads of payment. Compensation as an expression includes all of them. Now what the trial court has done is that it has violated Section 23 because Section 23 allows, what it permits is grant of solatium at 30% only on the excess of the market value, not on any of the damages. The learned trial court has granted solatium on the entire amount, which is not permissible.
Yes.
The third point, my lord, is that there are two forms of grant of interest that is envisaged under the Land Acquisition Act. One is the interest which is granted on the award, the original award passed by the collector, and the second is award interest which is granted by the court on the enhanced compensation which is rendered by the court itself. There, well, there are two periods for which the compensation is contemplated. One is 9% for the first year from the date of the Section 4 notification. So the first year from the date of the Section 4 notification, what is permissible, the prescribed rate is 9%. The court has granted 12%.
Okay, excess.
Yes. And the last point, my lord, is
on the awarded amount.
On the award, my lord, there are two amounts. One is the original awarded amount, and the second is the excess amount.
Okay.
So far as the second part is concerned, which is post 1 year of the Section 4 notification, the court has a discretion to grant the 15% with regard to the period. Now, as the lordships have seen, the case was pending for a very long time, from the reference in 2003 till 21. The court has not indicated why the entire burden should be allocated on the collector. For the entire period, in fact, I've shown from 2017, the matter was ready for hearing. For some reason or the other, judgment could not be passed. That could have been taken into consideration, and that period could have been exempted. But the court granted this 15% for the entire period, of roughly about 21 years. And in fact, also here, the calculation I'll show, that is prima facie incorrect, which has been recorded in the judgment as well as the decree. So on the first point, my lord.
Okay. So there are these 4 points, but you got 3. First, maximum compensation award without any reason.
Yes,
reasons erroneous parity without any basis.
Then there is
Second,
solatium.
solatium granted entire amount.
Yes.
Yes, which is the value of Section 23.
And
number
fourth
3,
is the
excess interest. Third is excess interest paid.
No, the third is the 12%, my lord. Under Section 28, the period for which the excess compensation, the interest can be granted. There are two parts to it. The first part relates to the period of 1 year from the date of the Section 4 notification. There, statutorily, what can be granted is 9%. Here, the court has granted 12% for all the claimants, which is not permissible.
And the first year.
And the last point is that, insofar as the second period is concerned, which is after 1 year of the
award.
No, 1 year of the Section 4 notification, court can grant 15, but the power is discretionary. Court should have looked into the period and could have exempted certain periods.
Okay.
That's for the first point. If lordships will have paper book volume 1.
Yes.
Lord, in paper book volume 1, I'll take your lordships to the judgment, which is at page 119. This is a judgment dated 17th of March 2020.
Yes.
So here the court discusses the history of the case and individually deals with all the claims of the claimants. As the first claimant, that is Armstrong, his case is discussed at page 135.
Petitioner number 1. I mean, the claimant number 1. Yes.
So just to give your lordships a sense of the claim and the reasoning and the evidence as well, I'll just read out this instead of going through all the other claimants, my lord. Kindly see from the second paragraph onwards.
Yes.
It reads, appreciation of evidence, decision and reasons thereof on the individual claim of claimants as under. Number 1. The claims of petitioner number 1, Shri Armstrong CM, are for enhancement of rates, compensation for hybrid tissue cultured plantation, Tita Champa trees, and damages to the iron fencing and iron gates. In his evidence, he deposed he has 2 plots of arable land situated at village Umdobirit, situated in the heart of the town, having lots of potential value and having iron fencing and iron gates, hybrid tissue cultured plantation, and Tita Champa trees, and that the collector has acquired the area of 918 square meters from the left-hand side of the first plot and 1,188 square meters from the right side of the second plot by severing the plots and thereby making the remaining portion of the plot of no use. Thus, according to the claimant, a total area of 2,106 square meters was claimed by the OP collector, on which total area he has come to know that the compensation was paid of rupees 1,68,480. Besides, 30% solatium and 12% interest with effect from 39/2001 to 7/7, this part is missing, at the rate of rupees 80 per square meters. However, that no compensation was paid for the hybrid tissue cultured plantation, Tita Champa trees, and to the damaged iron fencing and iron gate. His claims are A. For enhancement of rate from 80 per square meters to rupees 4,000 per square meter, thereby for the total area of 2,106 square meters, the claimant claims entitlement to enhancement of rupees 84,24,000. The claimant also claims solatium at 30% per annum from the date of notification under Section 4 of the LA Act, interest at 12% per annum on the market value of the land with effect from publication of the notification under Section 4 of the Act, and the claim for further interest at 18% per annum on the excess amount awarded by this court from date of filing of the claim application till full payment is made. From the evidence of claimant number 1 is seen that the sale deeds are commonly relied by all the claimants at Exhibit 4, 5 and Exhibit 6, which are all undisputedly not registered and unstamped, but the documents are also not executed at the relevant time of acquisition herein, but the same was relied for the rate of acquired lands herein as projected rates on assumption of rise of rates since 93-94 as per the sale deeds to 2003, expectedly to rise especially with the hike in the price due to coming of 4-laning highway. But on perusal of the said exhibits 4, 5 and 6 is seen not only rate is at variable from one another and not specific rate, but the lands therein are also not specifying on the type and classification of the lands therein, so that to enable this court to compare the value of land of the claimants herein. The acquired lands herein being referred commonly for all 68 referred claimants for a large extent of acquired land of 2,80,556.11 square meters, and the claimant number 1 admitted the extent of his land to be 2,106 square meters, while the sale deeds brought for supporting their claim of enhancement of rates is but of a small extent of land. As per the Honorable Supreme Court ruling recorded in so-and-so, at para so-and-so, the claimant is required to discharge the initial burden of proving that the amount of compensation determined in the award under Section 11 was inadequate. But when the claimant will succeed in proving that the amount determined under the award of collector was inadequate, the burden of proving the correctness of award shifts on the collector, who has to adduce sufficient evidence in that behalf to sustain such award. Court cannot determine the value of land unless it gets over the finality and conclusive evidentiary value attributed to it under section 12 by recording a finding on consideration of relevant materials therein that the amount of compensation determined under the award was inadequate for the reason that weighed with it. Assuming that Exhibit 4, 5 and 6 are sale deeds duly registered, I'll just point out these were not registered sale deeds. But the areas, so court is just drawing an assumption, but the areas as per the sale deeds as Exhibit 4, 5 and 6 extend only to their areas therein as 5453, 4450 and 5250 square feet respectively. For that also the court is not always bound to determine the market price of the land extent of the acquired land on the basis of the prices fetched by the alleged sale deeds of Exhibits 4, 5 and 6. For this view, it was held in the above ruling, cited ruling herein, above at para 14 and 22 thereto with the relevant portions thereof. Whereas sale deed or an agreement to sell relating to a small extent of land is produced by the claimant in the inquiry held for determination of compensation payable for his large extent of land, the court is not always bound to determine the market price of such large extent of acquired land on the basis of the price fetched or to be fetched by small extent of land covered by such sale agreement or agreement to sell. Besides, on perusal of Exhibit 4, 5 and 6 is not clear what kind of nature of land it is, since it is not reflected thereon whether it is paddy field or arable land or homestead or quarry land for satisfactory comparison to the acquired lands of the claimants herein this case. Decision. Hence this court on the issue of rate found the claimant not able to prove satisfactorily that the amount determined under the award of the collector was inadequate, since their reliance of the Exhibit 4, 5 and 6 are found not satisfactorily comparable to the land of claimant herein, as the type of land in the said sale deeds at Exhibit 4, 5 and 6 are not specified as to what type of land they are. However, since the land of claimant number 1 is apparently arable land, with the plantations thriving thereon, and since it is also seen from the assessment of collector to some arable lands of others, the assessed rate was rupees 100 per square meters, and to some others rupees 80 per square meter, and yet to some others rupees 160 per square meter. Hence this court awarded an enhanced rate of acquired land of this claimant number 1 to the rate of maximum rate as given to the others in the same acquisition, that is rupees 160 per square meter. B. For compensation for damage to hybrid tissue cultured plantation, of which he deposed in his evidence to have 840 numbers by relying on the certificate issued by the District Horticulture Officer, Ribhoi District, Nongpo, proved under his signature at Exhibit P11, and also relied for support on evidence of common witnesses number 75, Shri So-and-so, who deposed that he has made physical verification of his land and counted the plantation standing thereon, his land, and issued assessment certificate at Exhibit P11 by exhibiting his signature at so-and-so. Thus, that as per Exhibit P11 of common witness number 75.
Who is he?
Well, he is Evangeline Shampoo, retired District Horticulture Officer.
Okay.
Thus, that as per Exhibit P11 of common witness number 75, the trees found by him to be 840 numbers of plantation of banana trees, and his assessment of the total compensation of rupees 13,44,000, which claimant claimed entitlement. For the damage of Tita Champa trees, claimant deposed to have 160 numbers of such trees on the acquired, and which total value is rupees 8,96,000, supported by the certificate at Exhibit P11 issued by the common witness number 74, Shri Andrew Lingdor, Divisional Forest Officer, East Khasi Hills Division, Shillong, who proved his signature at Exhibit so-and-so, and who deposed in his evidence claimed to be a qualified divisional officer, and that he has made physical verification of the land of claimant number 1 and found 160 number of Tita Champa trees, class A1, Deng Rai trees standing on the land. Thus, claimant claimed the value of damaged 160 Tita Champa class 1 trees for 8,96,000. Decision. On issues at B and C above, since the claimant has been able to prove the damages of hybrid tissue cultured plantation of 840 numbers and damage of Tita Champa trees of 160 numbers, which the OP collector has not adduced evidence. Otherwise, nor could OP collector topple the evidence of the claimant's common witness number 74, District Horticulture Officer Ribhoi Nongpo, and a common witness number 74, Divisional Forest Officer, East Khasi Hills, Shillong, respectively, were also found qualified persons in the respective field related for assessment of such plantation, which remains unrebutted. Hence, this court is inclined to believe the claimed damage of number of such trees at above issues B and C of claim number 1. However, this court is of the opinion that though it would be fair to assess the potential earnings of the said plantations if not felled for acquisition, but since the assessment of PW 75 and PW 74 respectively was not explained if assessed on the lifespan or the size of trees and every trees, nor about the expected earnings from their products of each and every tree, but the documented exhibit P11 seems to be generalized every tree as the same size, lifespan and same produce. Hence, keeping in mind the assessment of PW 74 and 75 being by number of trees only as a lump sum assessment, hence this court will accordingly take the average lump sum rate calculation of 50% as base for the calculation for their claimed rate for compensation of their plantations. As such, for fair and adequate compensation, this court awarded the claimant number 1 with compensation on the damage of the hybrid tissue culture plantation by lump sum rate of rupees 800 per tree. Thereby, the total compensation for the said 850 banana trees awarded is rupees 6,72,000. Similarly, for the damage of the Tita Champa trees, this court awards the claimant at the lump sum of rupees 2,800 per tree. Thereby, the total compensation awarded on all 160 such Tita Champa trees, Deng Rai, is 4,48,000. For the compensation for damage to the fencing and the iron gates, claimant number 1 deposed that his 2 plots were having iron fencing and iron gates which were damaged, and he claimed for compensation of rupees 1,99,150 for damage of fencing and rupees 9,130 for the damage of iron gates, and in support he relied on valuation certificate by Assistant Engineer Civil Nehu Shillong, who exhibited the same as exhibit P13 as proved by his witness number PW 74 Shri Winter Rose Lingdo, who is well conversant with the procedure of assessment of rates of such structures and who proved the certificate by exhibiting his signature herein as exhibit so-and-so. Decision. On going through the certificate at exhibit P13, this court found that the assessment by the PW 72, a qualified engineer, on which was not disputed by the OP collector, and the same was found to be explicitly assessed with the materials, type and quantity so used for its construction, even with the deduction of depreciation value at 1% after 1 year from erection at 9% per annum, but this court found the assessment of PW 72 is not supported by any schedule of such rates for such assessment done by him in order to prove that this assessment is just, fair and adequate. Though this court believes in such damages of fencing and iron gates, but for fair and just compensation that would be adequate for compensating the loss of claimant would be by accepting 50% of the amount claimed as the actual amount of loss to claimant. Hence, claimant number 1 is awarded rupees 99,575 and rupees 4,565 for fencing and iron gate respectively. Reliefs. The claimant is therefore found entitled to 30% solatium per annum on enhanced compensation and with 12% interest per annum on the enhanced compensation with effect from date of taking over of the land till payment is made in court, and if amount is not paid in court within 1 year, an additional interest at 15% per annum shall accrue to the said awarded amount till final
this some substance. This is the uniform award given to all the
reasoning.
That is reasoning given that 30% solatium per annum, 12% interest per annum on enhanced compensation.
Yes.
And if after 1 year, 15%.
Yes. So I'm coming to the question of the solatium and all of that. This is wrong. In fact,
that's your case. You're saying that it covers all the 4 points that you have.
Yes, okay. So the solatium and the calculation will come to it later. The reasoning, as I was indicating earlier, if your lordships turn back to page 138, the court has noticed that there is a classification of land, different types of land.
Not discussed.
And because at page 138 there is no real reasoning as such. So the court says,
but with the rates fixed, like arable land, cultural land, forest land.
She doesn't really go into that. Yes, the court doesn't really go into that. That is that. Can you see the last paragraph at page 138? That is the limited reasoning.
138.
138. I'll read it again.
Yes, is that we've seen.
So the claimants have placed reliance on certain sale instances from 1993.
456.
Court does not accept that. Court says, firstly, these are unregistered. Number two, I don't know what kind of classification these lands are, and I can't rely on those rates. But the court sees that the collector has granted the maximum of 160. And she says, I don't understand why this discrimination, so therefore I'm granting everybody 160 maximum rate. That can't be a justifiable reasoning, my lord. So what the court has done has simply granted a uniform rate by homogenizing each and every claimant's lands. Now, as lordships are aware, I was just going through, in fact, in their claim petition, they have referred to the development in that particular area. So from 1975, that particular area stood developed with the establishment of ICR, SIRD, the Umroi Airport, the Umroi Cant. Now, if your lordships look at the other end, which is towards Soringham, there was not really any kind of development, similar to the kind of development in this area. So what the court should have done is adopted the belting method and then realized the actual value of the land. Because they say that this particular land is closer to town, and so therefore the valuation should have been much higher. Similarly, the court should have adopted that same approach for each and every single claimant. I'll just refer to one judgment. Lordship will kindly have page 583. But this is squarely on the point of uniform valuation of the land. At page 583, the last paragraph.
7.
Para 7.
Yes.
Yeah, read me note. The question whether the acquired lands have to be valued uniformly at the same rate or whether different areas in the acquired lands have to be valued at different rates depends upon the extent of the land acquired, the location, proximity to an access road, main road, highway, or to a city, town, village, and other relevant circumstances. We may illustrate. A. When a small and compact extent of land is acquired and the entire area is similarly situated, it will be appropriate to value the acquired land at a single uniform rate. B. If a large tract of land is acquired with some lands facing a main road or a national highway and other lands being in the interior, the normal procedure is to value the lands adjacent to the main road at a higher rate and the interior lands which do not have road access at a lesser rate. Where a very large tract of land on the outskirts of a town is acquired, one end of the acquired land adjoining the town boundary, the other end being 2 to 3 kilometers away, obviously the rate that is adopted for the land nearest to town cannot be adopted for the land which is farther away from the town. In such a situation, what is known as a belting method is adopted, and the belt or strip adjacent to the town boundary will be given the highest price. The remotest belt will be awarded the lowest rate. The belt strips of land falling in between will be awarded gradually reducing rates from highest to the lowest. D. Where a very large tract of land with a radius of 1 to 2 kilometers is acquired, but the entire land acquired is far away from any town or city limits without any special main road access, then it is logical to award the entire land one uniform rate. The fact that the distance between one point to another point in the acquired lands may be as much as 2 or 3 kilometers may not make any difference. So we're not covered by D, but at best by B and C, which talks about that whole belting method. So here the case in point, the court could have obviously looked at this issue, that the areas closer to the Umiam Dam were far more developed compared to the areas towards Soringham.
So these lands are all on the stretch, you mean?
On that stretch.
So they should have been...
So on both sides of the road, they had acquired areas.
Reasonable classification.
So the reasoning adopted by the court, in fact, the claimants are also not happy in their cross appeal. They've also said that this reasoning is absolutely wrong. Of course, they say that the court should have adopted the sale exemplar by looking into those sale deeds. But the court has rejected that. They will try and make an endeavor before this court that this court takes into account.
Were those exhibits tested? I mean...
Yes, my lords. In the second additional paper book, they are exhibit 4, 5 and 6. They are dulies. They are not registered sale deeds. They're from different times. Usually the proximity should be 5 years preceding the Section 4 notification. Those are from 93, 94 and so on. So the court has said that we can't look into that. Number one, it is unregistered. Even assuming it is registered, then the question is we don't know what sort of land it is. So therefore we can't really compare it. Now, while the court does talk about the comparison with the sale classification of land, here it falls short in its reasoning. It does not look at the classification of land and simply grants a uniform rate without any explanation. Because ultimately this is public money.
Yes.
This can't be distributed in this manner. So this is one point, my lord.
1 second. Yes.
Hello. Kindly come back to page 141. I'll just show Lordship's prima facie that the award of solation was also incorrect.
Yes.
At page 141, at the last paragraph, these are the additional reliefs that were granted. So I'll just read this again, my lord. The claimant is therefore found entitled with 30% solation per annum. This is incorrect. I think they've acknowledged that, and which is why subsequently after the rendering of the main judgment, they filed an application under 152 for this correction, that this 30% is a lump sum grant. It is not per annum. So that was corrected by the court. In any case, the original judgment read 30% per annum on enhanced compensation. This is a faulty method of granting solation. Kindly have section 23 of the Land Acquisition Act.
1940 Act. 1940 Act.
Yes, 1894. 1894. Section 23.
Yes. Section 23. Yes.
Lordships have section 23.
Yes. Matters we consider.
Lordship. Matters to be considered in determining compensation. Now, this is what is to be considered by the collector as well as the court.
Yes.
It reads, subsection 1. In determining the amount of compensation, kindly see the expressions that have been used, my lord. In determining the amount of compensation to be awarded for land acquired under this act, the court shall take into consideration, there are a total of 6 considerations that will prevail on the court. Number 1,
yes,
the market value of the land at the date of the publication of the notification under section 4, subsection 1. Second, the damage sustained by the person interested by reason of taking of the standing crops and trees, which may be on the land at the time of the collector's taking possession thereof. Third, the damage, if any, sustained by the person interested at the time of the collector's taking possession of the land by reason of severing such land from his other land. Fourthly, the damage, if any, sustained by the person interested at the time of the collector's taking possession of the land by reason of the acquisition injuriously affecting his other property, movable or immovable, in any other manner, or his earnings. Fifthly, if in consequence of the acquisition of the land by the collector, the person interested is compelled to change his residence or place of business, the reasonable expense, if any, incidental to such change. And sixthly, the damage, if any, bona fide resulting from diminution of the profits of the land between the time of the publication of the declaration under section 6 and the time of the collector's taking possession of the land. So in total, the expression under section 23(1), which is amount of compensation to be awarded, comprises in total of these 6 heads of payment. So market value is one head, and then the different heads of payment which are damages on account of various losses. Now then kindly see subsection 2.
In addition.
Lordship. So it starts with in addition. So in addition to what is being paid, that is the compensation, the total compensation.
Market value.
Yes, in addition to the market value of the land or not. It does not say in addition to the compensation. here and above. It only talks about market value. So let's assume for a moment, Lordships have seen the market value here, what was awarded by the collector is 160 per square meter.
Okay.
And it brings the total to whatever amount, X amount. And then the court holds Y for Tita Champa trees, Z for something else, and then something else for the fencing. What the claimants have done, or what the courts have done, they have taken the entire total and granted the 30% solatium per annum on the entire total. Whereas subsection 2, what it provides is that the 30% one-time payment is to be payment only on the market value. That is that 160 rupees per square meter. So in this particular case, the 160 per square meter brings the total, which is the market compensation, to 3,36,960. Instead, so what the 30% solatium should have been awarded only on this 3,36,960.
Not the additional amounts.
Not on the additional amount. So this, my lords, I find support in a judgment of the Honorable Supreme Court. Kindly have page 737.
1 second. So it has been 30% was granted beyond the scope, section 23.
Lordship?
30% was granted beyond the scope of section 23.
Yes,
That's
30% can be granted, not per annum. Anyway, that they have
yes,
considered.
beyond the scope of the as
Yes,
allowed by the.
Yes, it has been granted on a much higher amount than what is contemplated.
Yes. Judgment is 2011.
Lordship, I'll take your Lordships to page 739 onwards. So, my lords, firstly, the court is already granting compensation under section 23(1) under the 6 different heads. Subsection 2 is an additional, the solatium is an additional compensation in lieu of the compulsory nature of the acquisition. So if your Lordships have page 739, I'll take your Lordships to para 10 onwards.
Yes.
It reads, section 23(1) refers to market value of the land on the date of publication of the notification under section 4(1) of the Act as a relevant factor for determining the amount of compensation to be awarded for land acquired under the Act. Subsection 2 provides that in addition to the market value of the land determined under section 23(1), the court shall in every case award a sum of 30% on such market value in consideration of the compulsory nature of acquisition. Subsection 1A of section 23 inserted by so-and-so provides that in addition to the market value of the land as provided under section 23(1), the court shall in every case award an amount calculated at the rate of 12% per annum on such market value for the period commencing on or from the date of publication of the notification under section 4(1) in respect of such land to the date the award of the collector or the date of taking possession of the land, whichever is earlier. Now this is relevant. The additional amount under section 23(1)A and solatium under 23(2) are both payable only on the market value determined under section 23(1) of the Act and not on any other amount. Solatium under 23(2) is not payable on the additional amount, nor an additional amount under 23(1)A payable on solatium. Solatium and additional amount are also not payable on damages, expenses that may be awarded under the 2nd to 6th factors under section 23(1) of the Act. Then kindly see para 12. Thus, a person whose land is acquired is entitled to the following amounts under the Act. Kindly see B. Solatium at 30% on the market value determined as the first factor under 23(1)A of the Act.
Okay.
So I'll come back to page 141 of the paper book. The language used here, my lord.
By the court.
Yes. 141, last paragraph.
The claimants
therefore found entitled with 30% solatium on enhanced compensation. Court does not say on market value. So like I said, the market value would only be 3,36,960. So to elaborate this further, Lordships will have the decree now. The decree is in the same paper book at page 326.
Yes.
So Lordship will find this is a decree which is also prepared on the date of the judgment. It bears the same date. The relevant part is at page 327. I'll take your Lordship to the fourth paragraph onwards.
Claimant number 1.
Claimant number 1. Claimant number 1 has already drawn the compensation awarded by the opposite party collector under protest on 19/8/2003. The said compensation included amount for the land measuring 2106 square meter at the rate of 80 rupees per square meter plus solatium at 30% plus interest at the rate of 12% with effect from 13/9/2001 till 7/3/2003 as follows. 1. In the table, my lord. Compensation awarded by the opposite party collector under section 11 of the Act is 2,55,685, the original amount. Then the next page. However, the court found that the claimant number 1 was entitled to claimant to be awarded an enhanced rate of 160 rupees per square meter. Total area of claimant number 1 acquired by the opposite party is 2106 square meter. Enhanced rate at 160 per square meter awarded by the court brings the total to 3,36,960, what I had already referred to earlier. Now, then kindly see the compensation. Your Lordship will find that serial number 3, lump sum for damage of hybrid tissue culture plantation. This is a total of 6,72,000. Then at serial number 4, lump sum rate for damage of the Tita Champa trees. It brings the total to 4,48,000.
Yes.
Then lastly, number 5, compensation for fencing and iron gate is 1,04,140.
Over 14 lakhs.
Yes, the total is in the next page, my lord. At serial number 6 in the table, it brings the total, kindly see 336, 672, 480, brings it to 15,61,100. Yes, and Lordship will see what's done here. The compensation is also found entitled, the claimant is also found entitled to solatium at 30% of the enhanced compensation, and the calculation is below. So what he gets is 4,68,330, which he is not entitled to. I was going through this. As per the market value of 336, if we apply the 30% one-time solatium, what he actually gets is 1,01,088 rupees.
Not 4
So
lakhs.
across the board, every single claimant has been given a huge amount, which they are not entitled to. So this, on the face of it, deserves to be interfered with. Now, the third point, my lord. Is on the grant
So your two decisions here, belting method, for non-classification of the different types of lands. Right, there was no reasonable, nexus between the finding and the amount awarded. There was no finding, correct?
Yes.
And next, that's a belting method. That's a decision in 2010.
That was not adopted by the court.
Solutions granted in violation of section 23.
Lordship.
2.
Those are the first two.
Right. Okay.
The third, my lord.
Third point
is interest on excess compensation.
Okay.
So if your lordships will have the act again.
Yes.
There are two interests which are provided for.
One second. Yes.
So, my lord, under the scheme of the Act, once the collector has drawn up the award, he is to give notice to the claimants and ask them to receive the money. In case they receive it, well and good. If they don't receive it, the money has to be deposited into a bank account, which will accrue interest. They are also entitled to receive it under protest so that they can pursue a Section 18 application. Now, the question of application of interest there is governed by Section 34.
Yes.
This reads
payment of interest.
Payment of interest. When the amount of such compensation, this such compensation refers to the compensation which is part of the original award of the collector.
Yes.
When the amount of such compensation is not paid or deposited on or before taking possession of the land, the collector shall, kindly see, it is mandatory. The collector shall pay the amount awarded with interest thereon at the rate of 9% per annum from the time of so taking possession until it shall have been so paid or deposited, provided that if such compensation or any part thereof is not paid or deposited within a period of 1 year from the date on which the possession is taken, interest at the rate of 15% per annum shall be payable from the date of expiry of the said period of 1 year on the amount of compensation or part thereof which has not been paid or deposited before the date of such expiry. So this relates to the original award by the collector. Now, as far as the excess compensation is concerned, interest thereon is governed by section 28, my lord.
Yes.
So this reads, collector may direct to pay interest on excess compensation.
Yes.
So this reads, if the sum which in the opinion of the court the collector ought to have awarded as compensation is in excess of the sum which the collector did award as compensation, the award of the court may direct. Now this, the language instead of shall, this says may. So this is discretionary. May direct that the collector shall pay interest on such excess at the rate of 9% per annum. Now it does not use the language shall pay interest not less than 9%, but it makes it mandatory that the amount shall pay only interest at 9% per annum from the date on which he took possession of the land to the date of payment of such excess into court, provided that the award of the court may also direct that where such excess or any part thereof is paid into court after the date of expiry of the period of 1 year from the date on which possession is taken, interest at the rate of 15% per annum shall be payable from the date of expiry of the said period of 1 year on the amount of such excess or part thereof which has not been paid into court before the date of such expiry. So, the grant of interest under section 28 on the excess amount cannot exceed 9% for that initial period.
Yes. Even the heading says collector may be directed.
May be directed. But in the present case, without any explanation, the court has granted 12% interest for the first period.
Yes.
So, my lords, while that is there in the judgment itself, lordships will kindly have the decree at page 330.
I thought I flagged it here. This is regard to which claimant?
Same Armstrong, the first claimant.
Okay.
At page 330, at serial number 8.
Yes. 12% interest per annum.
12% interest per annum on the enhanced compensation at 15,61,000 with effect from 13/9/2001 till 12/9/2002. That is 1 year from the date of taking over possession. This is completely counter to the provisions of section 28, which only provides 9% for the 1 year. So the amount here which has been granted is 1,87,332. But if we calculate it at 9%, the amount is actually 1,40,499.
Yes.
So there's an increase of about 47,000. So this has been adopted for every single claimant, the solatium and the interest at 12%. So there's a huge difference in the actual entitlement.
So same with 15% also.
Yes, for everybody this has been granted. It's absolutely incorrect. Could not have been granted. It drastically brings down the entire amount. So I'm just looking at it. It's 3.5 lakhs plus. So here the actual difference would be about 4 lakhs.
Okay.
Actual difference is 4 lakhs. Then last point was the interest for the second period of the period after 1 year. What the
15%.
court has granted is 15%. This is a discretionary power. Now, the court has itself recorded in its own order that the case was pending since 2017 for judgment, and the judgment was actually rendered in 2020 in the month of March.
20?
Yes, my lord. The presiding officers could not pass a judgment, so I think there were about 3 presiding officers who heard it. The third finally rendered the judgment. So it could not have been said that the delay was completely attributable to the claimant, to the collector. There is no discussion at all. So once the grant of that compensation for the subsequent period is discretionary, court could have looked into that aspect. I'm not saying the court is to reduce the 15%, that it can't. It remains static. But the period for which the grant is made, there the court could have looked into it because it's a discretionary power. Well, on that point, I'm referring to one decision. Sir, I'll be letting make a thing. I'll give it to you. 2009 8 SCC 412. 412. So the relevant part is at page 425.
Four?
425.
Para 33.
Para 33. Yes. This reads, the award of interest under Section 28 of the 1894 Act is discretionary. Section 28 applies when the amount originally awarded has been paid or deposited and when the court awards excess amount. In such case, interest on the excess alone is payable. Section 28 empowers the court to award interest on the excess amount of compensation awarded by it over the awarded amount by the collector. The compensation awarded by the court includes the additional compensation awarded under Section 23(1)(a) and the solatium under 23(2) of the said Act. This award of interest is not mandatory but is left to the discretion of the court. Now, discretion, my lord, it has to be informed by reason. Court could not have exercised discretion in this manner.
Yes.
And just on that point, Manu, the fact that the court's discretion must be informed by reason, I'm referring to this decision.
OSCC.
And well, just before I do that, I just missed one particular aspect of this. This is another sub point under this. This 12%, in fact, this judgment says this 12% is to be granted only on the excess compensation. But what has happened, they've calculated the excess compensation on the total amount of land without factoring in what has already been withdrawn. He has already withdrawn some amount of money, but the court calculates it on the actual amount without deducting what has already been withdrawn by him. So kindly see that features at same page 330 at serial number 10.
It could, computes it at the same amount.
My lord, so the court had already discussed that he has already withdrawn a sum of 2,55,685.
Or deducting the withdrawn
Yes.
amount.
So on the excess amount of 330, court should have first deducted this amount, 255. It would be left with nothing. But the court has not withdrawn this amount, has not deducted this and calculated this 12% on the total amount. In fact, on this I was reminded of the NIPCO case unjust enrichment. This is exactly a case of that nature, my lord.
Not to that extent. That was
Thousands of crores, of course.
That was one thing that really shook. Yes.
So, Lordship, in para 33 of that judgment of Ghanshyam, it says it can only be on the excess amount. So, excess amount we've already seen, it comes to 330,960. So, we would have to deduct the amount which has already been withdrawn and then apply the 12%. But the court has not deducted this amount of 255, which is already paid. Amount. Yes. So, your Lordships will see at page 330 of the decree at serial number 10.
I didn't flag it. Yes.
At page 330. Kindly say serial number 10.
Difference. Claimant already drew 22 lakhs or 19 lakhs.
Now, this is the amount that the court is arriving at. This is based on an incorrect calculation completely and based on an incorrect judgment. So, on this, the court finally deducts 255. Whereas, as per law, you have to deduct the principal beforehand. So, the court calculates the entire interest and then deducts the principal which has already been paid in 2003. What should have been done is that this amount should have been deducted from the original amount, that is 336,960.
Where do you get amount from?
My lords, if your lords will kindly come back to page 327.
Yes.
So at 327, the court says, under protest on 19/8/2003, he has withdrawn this amount of 255,685. This is the original market value as was granted in the award by the collector. This amount. Can you see that paragraph? Claimant number 1 has already drawn the compensation. Under protest on 19/8/2003.
On 19/8/20.
So this was based on the rate of 80 rupees per square meter.
Yes.
So this was withdrawn in 2003 itself. Now can you see the next page? That enhanced compensation of 160 is calculated on the total area, 2106, which brings the total to 336,960.
336, yes.
Yes. So now what should have been done for the application of the interest under section 28, because 28 clearly says it is only on the excess compensation.
You remind us this amount.
Yes, yes, my lord.
From the 336.
That has not happened here.
Okay. Yes.
So I was referring to that last judgment, my lord, that discretion should be informed by reason. I'm referring to page 425, para 33.
This is the 2011-4.
2009-8, Commissioner of... Sorry, I apologize, my lord. This is 2011-4, yes.
Para?
Page 373, para 29.
Yes. Yes. Yes.
This reads, the use of unduly strong, intemperate or extravagant language in a judgment has been repeatedly disapproved by this court in a number of cases. Whilst considering applications for condonation of delay under Section 5 of the Limitation Act, the courts do not enjoy unlimited and unbridled discretionary power. All discretionary powers, especially judicial powers, have to be exercised within reasonable bounds known to the law. The discretion has to be exercised in a systematic manner informed by reason. So in this case, I'm on the question of that discretion with regard to that 15%. Court could have taken that into consideration, whether the entire delay or the entire period of pendency was attributable solely to the collector. Because a lot of developments took place. The matter was heard, the matter was transferred, records were transferred, so it was not entirely attributable to the collector. And it was pending since 2017. These aspects should have been looked at, it would have brought down that interest rate. So these are the 4 initial points which I thought would catch the attention of the court, and which, on the ground of this, the judgments and decrees deserve immediate interference, my lord. So I'll pick up again on the next day.
Okay. Yes, Mr. General, you won't reply now?
No.
You save your reply.
Reply at time.
Because, yes, I mean, if we can have it brought for parameters, is good, and, like, match it with the law.
We can continue tomorrow.
Tomorrow I have another hearing. Monday ko leave, Monday ko. Week में hearing है, इसलिए मैं बोला.
Monday के.
Whatever date is convenient. If Monday is convenient, my lord.
Because link, if it can be done continuously, because in all the cases, same position. We don't have to take individual cases. From one case, what is decided for all the cases.
Only one thing this court wants to know, whether you still want to examine that aspect, whether a common appeal is maintainable.
Yes.
You want to examine that.
Yes.
You want to argue that.
Yes.
To say that for every claimant against every claimant, there should be a separate appeal.
Separate appeal, and that
but
is
they paid
because
the court fees
because
cumulative for all for all the claims.
Admitted maximum court fees.
Maximum court fees already been paid.
yes, on one appeal.
Now whether you bring out, you took some rulings in, whether that we can, that aspect, since the court fee has been paid. What the High Court rules say on that point?
It's silent. In fact, there are no precedents on this issue. As far as CPC is concerned, there are. That if there are multiple suits, they can be clubbed together for a common trial. They can have a common judgment, but eventually there has to be individual decrees and then individual.
Once the individual decrees, there have to be individual appeals. Well, that is the self position. But whether in this case, whether some exception can be carved out.
But if there is a single suit which is filed in a representative capacity or for different plaintiffs, then it has to be a single appeal that follows from that. That is the general rule.
Yes.
So in this case, if we look at it,
but if
we apply the
Mr.
same.
General still, he insists on that, but then they'll be hit the same way with your appeal also.
The cross appeals go again on the same issue.
One cross appeal will file, against the decree by, jointly, correct? By all the
yes, Lordship, that is there. That is there.
So for 47 claimants.
Because for the four objections,
no, because it is for the reason, Lordship, that if his appeal is found to be not maintainable, my cross appeals also goes.
Exactly.
Cross appeals also, cross objection goes. And whereas there are 6 appeals which are separately filed, those remains for discussions.
Well, I'll come to that, then those will also consequentially fail.
No.
They will all fail. I'll
cannot
point out
fail.
the law on the subject, my lords. I'll point out the law on the subject, all of them will fail.
Let's supposing his appeal fails on the point of maintainability, not on merit.
No, on the
point of
maintainability, whether they still want to press upon it. That's the only thing. Or we go ahead and hear the appeal.
My learned senior had informed me last week that he doesn't want to press it, so I did not touch that issue at all.
No, later on, Your Lordship, I was. I thought that this point was since left open.
No, but here, of course, left open, but then if see 3 out of 4 considerations, 3 are gone.
Lordship.
3 have gone.
Yes. Then?
1 is left.
And this will only increase the burden. Lots will dismiss it on maintainability, their cross appeals go. We will all come back with individual 47, 48 appeals. It comes down to the same thing again.
Yes, no, that will take consideration. But if Mr. General insists, then the court has to consider it. That's the only thing. We can't shut you down. I mean, if it's a valid point which you raise. Yes, list for further hearing on. Now the May, correct?
22nd.
No, now 22nd. This on 29th.
29th.
I was quite burdened because we had some short.
As a part of matter, Lordship has first.
It can't go to any other bench.
It can't go. No, not that. So that it comes on the top.
Okay.
That is only the idea.
Yes, that's a part of matter.
Item 23.
Obliged.
please. The petitioners, shall we start on?
Yes. I can't hear you. Why are you speaking so softly?
I have some problem with the throat, my lord.
Then use the microphone.
No, my lord, the petitioners before your lordship are ex-employees of the Meghalaya MEDCL, Meghalaya Electronics Development Corporation Limited. My lord, this MEDCL is a wholly owned subsidiary company of the MIDC, Meghalaya Industrial Development Corporation Limited. The grievance of the petitioners here, my lord, is non-payment of their full and final benefits consequent to a golden handshake extended to them.
How many petitioners are here?
My lord, there are 12 petitioners before your lordship.
In the entire staff?
My lord, what remains of the 17 people who were retained, who were retained, here what has happened, my lord, the golden handshake was extended in two phases, my lord.
Yes.
The MEDCL initially had about 59 employees, out of which 42 were extended the golden handshake in the year 2005. Now these 42 employees were given full payment, the entire package at prevailing pay scales in one go. Now 17 were retained. Now out of these 17, my lord, 12 are before your lordships. Now, one of these 17 were retained, or the assurance that they will be absorbed in other other organizations of the parent company, and there was also talks of diversification of the subsidiary holding, that is the MEDCL. However, none of these happened. So, from 2007 to 2010. The company which was once producing state-of-the-art tantalum capacitors, and which had clients like Siemens.
What are they called?
My lord, these are called
tantalum capacitors.
Tantalum capacitors. These are used in the aviation industry and other things.
Defense and aviation.
Yes, my lord.
No, they even use rocket engines.
Yes, my lord. It was this company at one point of time, my lord, it was doing quite well, my lord. It had clients like HAL, Hindustan Aeronautical Limited, Siemens, and BEL, Air France, etc. Now, this company, which was then producing these kind of state-of-the-art equipments, my lord, became an agent of sale, and for some years,
agent of
this Steel Authority of India Limited, and for some years, that is from 2007 till 2010, was selling steel.
Total turnaround, I mean.
My lord, total turnaround. Total misadventure, my lord. This is the fate of most companies, my lord, which is most state-owned public sector companies, my lord.
Yes.
Now, my lord, coming back to the issue at hand. Now, these 17 employees who were retained, where the government decided that they cannot run the company again. So they decided to give them a golden handshake. Accordingly, my lord, an amount was arrived at, which was 245,000.68 lakhs if the golden handshake was to be extended on the 31st of March 2009.
2 lakhs?
I'm sorry, 2 crore 45 lakhs 68,789 for all the 17 employees. If the golden handshake was to be extended on the 31st of March 2009. However, this was not to happen. What happened was that out of this 2 crore 45 lakhs 68,789, the funds were released in 2 installments, not the entire amount. They were released in 2 installments. One installment of 112.20 lakhs in the financial year 2009-10, and another installment of 113.48 lakhs in the financial year 2010 and 2010-11.
Okay.
Now, meantime, the benefits of the fourth commission was extended to the employees of the MEDCL as well. Now, my lord, thereafter,
If you're already in the process of the golden handshake, then why?
my lord, the global,
Okay, just come again.
My lord.
Now you see what is the cutoff date for the corporation to come up with that amount, 2 crore something? What is the cutoff date?
My lord, if it was given at that point of time, my lord, it was 31st March 2009. But fourth pay commission was extended in.
No,
my lord.
Your contention is that there was an agreement that will be golden handshake for all employees, correct?
Yes, my lord.
42 employees, 17 employees, whatever.
Yes, my lord.
And then that the
My
cutoff
lord.
date for accepting the golden handshake of the amounts to be paid was a certain date in?
My lord, if it was to be paid, if it could be paid on 31st
That is your
March.
contention. I'm not saying that is a fact, but is the contention that it was to be paid, should be paid on which date?
If it was to be paid on 31st March 2009, the amount would
The
be.
entire amount.
The entire amount would be 245.68.789.
To all 17 people. That means after that everything's over.
For all, yes, my lord.
No more claims.
No more claims, my lord.
Right. Then
Now,
what happened?
now thereafter, what happened, my lord? With effect from 2000, since the entire amount was not paid, with effect from 2007, the benefits of the fourth pay commission was extended to these employees also. Now the government asked the director of MEDCL to furnish a revised plan, including the benefits of the fourth pay commission. Accordingly, my lord, this is at Annexure 2 and 3. If I may take my lord to Annexure 2 and 3.
Yes.
I am directed to invite a reference to letter number so and so from the MIDC corporation, copy of which has been forwarded to you, and request you to submit a revised fund requirement to the government for final settlement of VRS GHS with implementation of the fourth pay commission by the government of Meghalaya in respect of the staff of the MEDCL.
Then, make sure.
Then thereafter, my lord, a revised estimate was paid. My lord, the
By
revised.
the respondent.
Yes, my lord.
Yes.
The revised estimate came to about 536, inclusive of what was already paid. 536 lakhs.
Annexure 4.
My lord, this is at Annexure 4.
Okay. Revised fund requirement.
Yes, my lord.
Yeah.
My lord, gross total.
290.
My lord, 536.62.
Where are you getting
after,
that?
After excluding whatever was paid is 290.84.
That's the net amount, yes.
That is what was required to be paid.
292.9 crores.
290.84 crores.
No, 290 lakhs. That
Oh,
is.
2 crore 90 lakhs point 84. It is, yeah, the figures are in lakhs, 290 lakhs point 84. Now, my lord, thereafter, there was a meeting of the board of directors of the MEDCL, which was held on the 18th of April 2011. Now, my lord, by this, it was decided that the cutoff date for the purpose of VRS and areas of salary payable to the employees of the MEDCL would be July 2011. My lord, this, my lord, will find it Annexure 5.
Okay.
My lord, however, despite fixing this date, despite asking for the revised estimates,
yes,
as per the fourth pay commission, they were not paid. The last known payment was made in sometimes in 2014. My lord, the last payment was made.
Where do you get that? From your petition or from your annexures?
My lord, I'll just come to it now.
You will pay regular salary till then.
My lord, we were
paid salary.
We were paid regular salary till 2010, till December 2010. We were paid regular salary, my lord.
Okay. Regular salary till 2010.
2010.
Then this meeting, what did it say?
My lord,
Meeting
this
you referred to.
This meeting decided the cut-off date, my lord.
Cut-off date decided to from which date?
Cut-off date July 2011.
That means the whole handshake of BRS scheme
Yes, my lord.
to take effect from that day. Which exact date is it? Is it July?
July 2011, my lord.
Okay.
31st July 2011.
Okay. Yes. So that's it. Then what happened after that?
Now, thereafter, my lord, no payments, etc. were made. No payments have been made.
And you not paid a salary also?
No, my lord. No salary.
Then?
So, my lord, now, my lord, the law, my lord, as it stands is, my lord, the dual relationship between an employee and employer continues till the time, my lord, till the time, in case of retirement under such schemes, till the time the entire payment is made. Because VRS is nothing, it is.
Now, you mean to say that you have accepted the Golden Handshake scheme?
My lord, we accepted the Golden Handshake
Right.
scheme.
So, and the first, according to you, should have been implemented in 2009.
It ought to have been implemented in 2009. At that point of time, the government was supposed to pay us 245.
You get 245.
They did
and
not
when
pay.
It came to 31st July is 2.9 crores.
Yes, my lord.
So that's the thing. So you accept it, but the fact remains that you are agreeable to accept the Golden Handshake, correct?
My lord, we are left with no other.
There's already been. What happened to the other employees? What was the
now, my lord,
what was the method used to? I mean, how did it?
My lord, the earlier employees, the earlier set of 42 employees, my lord.
42 earlier. You have 17 later.
Yes, my lord.
Yes. How were the
now the earlier set of employees were paid in one go. In one go at prevailing scales. They got the benefits of the third pay commission. They
why
were paid
didn't
in
you?
one
Why
go.
didn't you? Why were you not clubbed together with them at that point of time?
My lord, we were retained for the purpose that the company would diversify into
Maybe revive.
Yes. Maybe revive or diversify, or we will be absorbed into the parent unit. But none of that actually happened, my lord.
Okay.
None of that actually happened. My lord,
So they made a plan. So, okay, fine. You take Golden Handshake at 2009.
Yes, my lord.
There will be amount.
It is.
So 2009 didn't do anything, but they continued to pay you till 2011.
My lord.
And after that, what happened? Then cut-off date meeting was held. 31st
Cut-off date,
2011.
my lord, and that
what
was
happened on 31st July 2011?
My lord, after July 2011, after the cut-off date was notified, we were last paid in 2014, my lord.
Okay, fine. So you couldn't be paid till 2014.
2014, we were paid 142 lakhs. Now, my lord, as per the last...
So it means that the amount will decrease. It can't be increased. Not that you're not being paid.
No, my lord, as per their last...
Yes.
As per the last communication between the Director of Commerce and Industries and the Managing Director MEDCL, my lord, what remains to be paid to us as on taking into consideration 31st July as the cut-off date is 181 lakhs 15,481. That is as per Annexure 12. That is the communication. our contention here, my lord, is that firstly, there is a unilateral
Now it's a
fixation of
registered
cut-off
company,
date.
correct?
My lord.
It's a registered company.
My lord, it is a registered company under the Companies Act, my lord.
Yes, my lord. It's been wound up.
My lord, it has, my lord, the winding up is not yet complete, my lord.
Till now?
My lord, what has happened is that since it is a subsidiary company, my lord, since it is a subsidiary company, the assets and liabilities of the subsidiary company has been transferred to the parent company.
To the holding company.
To the holding company. So therefore, my lord, what we are required to pay, to be paid is a liability of the company, my lord. That has to come from the holding company. Now the holding company, who is the holding company? The holding company is a company wholly owned by the state.
Yes. Okay. It's not wound up as yet. It's still existing.
No, it's not wound up. That is as per the affidavit. So while this is the case in a nutshell.
So what do you want now? You've not said what you want.
My lord, what we want?
You want a full handshake to come early.
My lord, we want whatever we are entitled to, my lord. Our prayer is twofold, my lord.
Okay. What are entitlements? Now you say that you agree that amount which was, computed to, was calculated to be you're entitled to.
My lord, as per their
amounts.
My lord, as per their own admission, we are entitled to, as per their own admission, taking into consideration that
do we have any quarrel with the amounts arrived at? Suppose they say, okay, fine, 10 lakhs is required for golden handshake. Do you have any quarrel with that?
No, my lord.
The amount doesn't satisfy you. What do you want now?
My lord, as per their own admission, my lord, as per their own admission, 1,81,15,481 is yet to be paid to us.
Fine. So they say that means an admission on their part. Are you ready to accept that and go?
My lord, the prayer in the writ petition is slightly different, my lord.
That is what the court wants to know. What's your prayer?
My lord, our contention is that there has been a unilateral decision on the cutoff date. We admit that it is the right of the employer, my lord. But once the cutoff date is decided, a golden handshake is extended, my lord. The law requires that whatever is the compensation in lieu of the golden handshake has to be paid in one go. Now, failure to pay that compensation in one go, my lord, continues the dual relationship between the employer and the employee.
You mean to say that...
now, my lord...
Okay, yes.
What I mean to say, my lord, would... it may not sound very good to my friends, but my contention is that, my lord, since they have not yet paid... Yes, my lord. Since they have not paid till date, my lord, that relationship, employer-employee relationship continues, my lord. And what we are praying, my lord, is that since the last payment was made sometimes in the year 2014, let 2014 be officially earmarked as a cut-off date. And no, my lord, nothing has been paid to us. Nothing has been paid. Nothing, my lord. My lord, it is not that we are not working out of our own will, my lord. We have no...
It happens.
We have no avenues to work, my lord.
Let's see your prayer.
Page 21.
That's all. Yes.
Wait, please, Your Lordship. Your Lordship, I'm appearing on behalf of the respondent number 4 and 5, which is the MIDC and the MEDCL, Your Lordship. So 5 and 6, Your Lordship. Now, Your Lordship, the respondent number 5 is the holding company. The Meghalaya Industrial Development Corporation is the holding company, and the respondent number 6 is the subsidiary company, Your Lordship. And the holding company is the parent company of the subsidiary company. Right. Now, the subsidiary company, Your Lordship, is to sustain itself. Is to sustain itself by its own operation and by its own income and all that, Your Lordship. No one provides funds for them, Your Lordship. Now, Your Lordship, only the holding company, which has got a limited share in that subsidiary company and owns limited share in the subsidiary company and controls the management and the policy decision of the subsidiary company, does not take part in the day-to-day operation of the subsidiary company, Your Lordship. And it can only give loan to the subsidiary company as and when they require the loan. So, Your Lordship, from the beginning, the subsidiary company, Your Lordship, was floundering, Your Lordship. It never did any good business.
No, fine, but then what happened to other 42 employees? Where
The
did the money
40,
come
that is
from?
why, Your Lordship, out of the 59 employees, Your
The
Lordship,
40 how were the 42 employees settled? Did you get the
they
same
were
kind of
also
treatment?
given. They were also given golden handshake,
by
Your
whom? Where did
Lordship,
the money come
by
from?
the government.
Then?
By the government, Your Lordship. So, as per the Third Pay Commission, they were satisfied. They are not in the picture anymore. Now, Your Lordship, the remaining 17 were retained with the hope that this company, the respondent number 6,
Now is feels
would
so
be
give them
able
the
to.
give them the same treatment, Nish.
No, Your Lordship, we have already released 387 lakhs to them, Your Lordship. Not we, meaning the government, Your Lordship, has given them. Now, Your Lordship, they insist that they should be paid as per the Fourth Pay Commission. Now, Your Lordship, even the employees of the respondent number 6 are not government employees, Your Lordship. The Fourth Pay Commission will not be applied to them, Your Lordship.
That is a given.
Yes,
but if
Your
you have
Lordship.
given the other people, see, the recommendations, whatever you accept, you're an autonomous body, you're not bound to accept the recommendations.
Yes.
Correct. So the thing is that if you have implemented the Third Pay Commission with regard to the employees, well and good.
But
now
in
the
this
fourth one
case, Your
special,
Lordship,
but now what amounts are you ready to give? Who's the paying for the state? Like whether they can advance the same assistance?
Your
that you give
Lordship,
the
I
other
would like to
employees?
take Your Lordship to page 44, which is annexure 9 to the writ petition, Your Lordship. Here you will find, Your Lordship, the
Yes.
the computation of the payments already made. Page 44, annexure 9, Your Lordship. This was minutes of the meeting held on 4/5/2016 at the office chamber of the Principal Secretary in charge Commerce and Industries Department with the Meghalaya Electronic Development Corporation employees, the retained employees, Your Lordship. Now, Your Lordship, in this case, Your Lordship, it's been stated that 31st July 2011 is the cut-off date, which they have accepted, Your Lordship. Now they are coming. Then, Your Lordship, to implement the submitted fund requirement statement was given. They gave an estimate to the government for the fund requirement as on 2011, Your Lordship. July 2011.
So they came up to 2013.
Then, Your Lordship, I beg your pardon.
Page 46.
Page 45, Your Lordship.
Yes.
There was an estimate given by them as per the Fourth Pay Commission. Then, Your Lordship, then after adjusting, again the said fund requirements, government after adjustment of payments earlier released the following amounts. Amount released earlier prior to the cut-off date was 2,45,68,000 already released to the employees, and they have received that also. Now, amount released after fixation of the cut-off date was 1,42,142.28 lakhs. This payment was made in 23/5/2014, Your Lordship. Now, Your Lordship, we have already made a payment of 387.96 lakhs to these employees, Your Lordship. And now, but as they insist, or as they had given an estimate, as per the Fourth Pay Commission, the amount is which has not been released and which they want that the government should release is 1,57,21,818, Your Lordship. So this was a meeting, and then in this meeting, Your Lordship, it was discussed thoroughly, and then it was also decided that the matter would be taken up with the government for examination and for due consideration. At no point of time, Your Lordship, have we accepted that we will be paying them as per the Fourth Pay Commission, Your Lordship. What has been given to them is on humanitarian grounds, Your Lordship. The government is not duty-bound to make this payment to these employees of a subsidiary company, Your Lordship. Then, Your Lordship, then as per the meeting of the 105th meeting of the board, Your Lordship, it was accepted that the decision of the government would be final, Your Lordship. whatever decision the government takes, because we are only to...
So the only thing boils down to that is that they're not happy with this amount. They've been paid 2014, they take the gold handshake, but they want the rate to be calculated as per
the fourth pay commission,
to
Your Lordship.
factor in the
And
fourth pay
which, Your
commission.
Lordship, the government
Like
is
for
unable
the
to pay,
legal.
Your Lordship. And here, Your Lordship, it has been said that the government has rejected that as we have already released so much, which we are not duty bound, but on humanitarian considerations, we have made the payment to these 17 employees, and beyond that, Your Lordship, they have rejected it. So, which is why, being aggrieved by that, they have come before this Lordship. And Your Lordship, my friend had also made a statement that the full package of 42 employees were given as per the third pay commission, not as per the fourth pay commission. Then there is also, Your Lordship, one statement, he had just made a submission, Your Lordship, that we had retained the 17 employees for the purpose of either for reviving the company or for absorbing them in the parent company, Your Lordship. That is also not true. Yes, we were thinking of reviving the company, which is why 17 employees were retained, Your Lordship, or diversifying. But that also didn't work out because the whole thing failed. But there was no assurance to these 17 employees that they would be absorbed in the holding company. That is not a duty of the holding company, Your Lordship. Then, Your Lordship, benefit of fourth pay commission was never extended to them. They were only asked to submit a proposal, an estimate, which they did. But the government has already released, as on July 2011, as per the third pay commission, and which they had also given to the 42 other employees who had gone earlier. So they have...
No, now, okay, fine. Can you come with a ballpark figure as to how it be paid to how much as per your
Lordship,
calculation they are due now?
Your Lordship,
take it, finish.
we have the government has rejected their request for anything.
They have unilaterally said that let me cut off 2011, so on and so forth. Apply.
Your Lordship, I had taken Your Lordship to this.
What is your offer? That's all. I mean, from the government.
No, I don't know. It's for the government to say that, but Your Lordship, as far as we are concerned, the holding company and the subsidiary company, we can only make proposals, Your Lordship, but we cannot because we don't have the fund.
Lordship.
Yes.
Lordship, my friend had submitted that the company has not winded up, Lordship. We have filed that for the good, Lordship, to the extent that the company winded up in the year 2008.
In 2008?
Yes, there was also a...
what happened to all the assets?
Lordship, if I may continue with my submission, later on...
Yes.
Then later on, Lordship, some of the employees were absorbed into other units of MIDC. Lordship, this was done by the corporation alone, and it's not within the purview of the state, Lordship. So, Lordship, whatever dues are there, it's within the third pay commission, Lordship, and this was done through the golden handshake and whatever fourth Meghalaya pay revision they are demanding, Lordship, is not within our purview because the company, company winded up in the year 2008. My Lord.
Where is that in the affidavit?
Lordship, it is at... My Lord, is at page 7 at paragraph 17, my Lord. And this is supported by a letter, Lordship, I mean the minutes held in the chamber of the Principal Secretary, Commerce and Industries Department, Lordship. If I may read paragraph 17, Lordship.
Yes, I've seen that.
That with regard to the averments made in paragraph 19 of the writ petition, the answering deponent states that MEDCL is not a government of Meghalaya undertaking. Monetary compensation given to the employees of EDCL is purely on humanitarian ground in the absence of any voluntary retirement scheme or golden handshake scheme notified by the state government. It is pertinent to state herein that the issue with regard to the payment of monetary compensation to the petitioners as per the fourth pay commission of Meghalaya was taken up in the meeting held on 14/7/2015. However, the meeting rejected the proposal since the company had already been winded up in 2008, Lordship. And there was no rejoinder filed to this, Lordship. So it stands.
What about the meeting that was held later on with that was where was shown?
My Lord?
That meeting at lecture 9 or something?
Lordship, as per our affidavit at page
see, this is
20,
if it wound up in 2008, you said.
2008, Lordship. This is as per Annexure 3.
Then this is Annexure 9, page 44. Minutes of the meeting held on 4th, 5th, 2016 in so-and-so. The means by Principal Secretary, Government and Practice Management is to fix a cut-off date for paying VRS employees on 31st as a cut-off date. Then we ask you submitted fund requirements to the government per cut-off date. This requirement was made. The balance pertains to early salaries. After the discussion meeting, I understand that the matter is being taken up with the government for examination and for due consideration. So what happened after this meeting? What happened after the Annexure 9 meeting?
Lordship, this meeting was 2016, my lord.
Yes.
The meeting that I have in hand with regard to the winding up is 2015, my lord.
Exactly.
And this is only with regard to the cut-off date. It does not overrule the fact that winding up of the company is 2008.
Winding up. The thing is that it's all. See, you read this page 46.
Lordship.
Yes, at a glance, you see, they have calculated. Page 46.
Lordship.
Net dues as on the cut-off date was 169.
Yes.
Net dues as on 31/7/2012 were 1283. Net dues on 31/6/2013 336. Now they've been paid till 2014. Correct.
Lordship.
Mr. Gautam. You've been paid till 2014.
Yes, my lord. That was the last payment made.
Even after that means after the company is wound up also, for whatever reason you were paid.
My lord, the statement that the company.
Now the only thing is that for the period from 14 till date now, then the government see this, what happened after you get instructions. What happened after this Annexure 9 meeting?
Lordship, then I have to seek instructions.
So the government was agreeable to say after discussion, the meeting had decision the matter will be taken by the government for examination for due consideration. So that's the thing. What happened? So whether you forget about your food pay commission, because that won't apply unless the company is alive and they recommend they accept the recommendations or apply the recommendation of food pay commission. Otherwise, it won't apply. Yeah.
Lord,
because Lordship, the fact that
companies wound up in 2008 is incorrect, Lord. Because winding up is a very long process, my lord. Winding up involves the appointment of an official liquidator, and my lord.
We're not going to go to that. The court is asking whether it's wound up or not, and now they've come and affidavit says wound up, and then okay, the raw materials you.
My lord,
get instructions, yes.
My lord, there is Annexure C in the affidavit filed by the company itself, MEDCL. They have enclosed the balance sheet.
Annexure 11.
How is the balance sheet?
Come to Annexure 12 now. Come to Annexure 12, that is 21/3/2017.
My lord.
Okay. You just see at paragraph 2.
My lord.
In July 2008, the government of Meghalaya advised the management to initiate steps to wind up the company.
Yes, my lord.
And to apply necessary funds for it, and to apply for necessary funds for golden handshake for the remaining 17 employees.
Exactly.
As such, MEDC by letter submitted a fund requirement to the government amounting to rupees 245 lakhs.
Yes, my lord.
Out of the amount when the government released the following funds, they released 100 and financial year 112 and 113.
My lord.
Further, government Meghalaya so some revised fund requirement as per the 4th mail permission. Again, as advised, the government board directors decided the cutoff, decided the cutoff here to be so and so, copy so and so. That's the fund requirement. Now, after this, what happened?
Lordship, this is a letter from MIDC.
From MIDC, yes.
Lordship, of course, there's a copy. This is to
my
the
lord,
department. Lordship,
after
I'll
that-
seek instructions on
after
this,
that,
my lord.
My lord, in 2013 and 14, my lord, the same letter says that, however,
See,
in the
Mr.
financial
Gautam,
year-
we can't have open-ended when we don't even know where you're standing right now, presently.
2013 and 14.
Whether what was transpired after that.
The government sanctioned an
After
amount of
hearing at some
142.
length, it appears that certain instructions are necessary, which are not available to the councils. This is the matter after 2 weeks, yes, for specific instructions. Number one, as to whether the companies will wound up, and whether, number one, whether the government has taken any action of proposals as submitted by the MIDC, as holding company of the, what's the company called? Meghalaya Electronic Development Corporation.
MEDCL, Lordship.
Item 25.
Much obliged, Lordship.
Basically, what has happened is, my lord, I was appointed way back in the year 1989 as a teacher in Ampati Government School, my lord. My service was regularized in the year year 1998. And thereafter in 2010, I was transferred and posted as the lady social education officer under the education department. And my ex post facto approval also came in 2017. Thereafter, my lord, what has happened here is that on 1st September 2022, I applied after having qualified, having rendered around 27 years of service. I applied for VRS. On the
you're not regularized yet.
Yes, and my thing was pending. My application for VRS was kept pending.
What happened?
Now, the intention for VRS was to participate in the election, which was the general election for the
elections?
No, legislative assembly elections last year from Ampati, and I have contested.
So you would withdraw VRS now?
No. What has happened is my VRS application was never answered. So I came before this honorable court with a writ petition just few days before the filing of the last date of filing of the nomination, saying that they should answer my VRS. Now, my lord, they replied to my VRS after filing of the petition that in view of the fact that my regularization has not been approved, my VRS could not have been accepted. In that situation, my lord, the first writ petition was disposed of. Now, in the meantime, on 1st of February, which is one day before the last date of filing the nomination, again I wrote to them saying that you have not considered that the fact that I was already regularized since 1998 and I have already rendered the qualifying service for applying for VRS. And in view of the compelling circumstances, I shot them a letter of resignation. And they immediately accepted it on the next date. I filed my nomination. Unfortunately, that didn't go well. I lost the election. Now, my lord, I am not here for withdrawing my resignation and asking for service again. I am here on the pensionary benefits. Because I have rendered, admittedly, my lord,
when do you regularize?
Lordship, if I may take the lordship through the...
You regularized through what? Through the...
I was regularized in 1998 by the inspector of schools then. Lordship will kindly have the documents.
Your initial appointment?
Initial appointment 1989. In the sanction, kindly see, my lord. Lordship will kindly have page 34 at annexure 1 and the type copy at annexure at page 35. Page 35 to the writ petition.
So, 1 second. Yes.
Lordship will kindly have page 35. This is my appointment order. It's wrongly reflected as 1889 in the type copy. I'm sorry, madam. The date is 21st July 1989.
Yep.
So and so allowed to continue as teachers with effect from 1st September 1988 in the newly provincialized Ampati High School, so and so, in the pay scale, so and so, against the post sanctioned by government order number. So I was appointed number 2, madam, Srimati Uttara D. Sangma.
You were the formal regularization order?
Yes. So this was my first provisional appointment in the sanctioned post. Thereafter, my lordship will kindly see the page 38. Page 38.
Yes.
On the approval of the additional director of public instruction, so and so, wide number dated so and so, the following assistant teachers in grade A, so and so, are regularized with effect from 28/10/1996.
Yes.
My name is at number 2, my lord. This was issued by the inspector of schools and the approval of additional director. Copy was given to the director of mass education and the concerned authority of the school. Now, so I have been serving there. Now at kindly come to page 43, lordship. Page 43 is the typed copy of the order at page 42.
Yeah.
Order dated 13th October 2010. In the interest of public service, the following employees of this directorate is transferred and posted as indicated. My lordship will kindly see serial number 5.
Yes.
Srimati U.G. Sangma, assistant teacher, so and so school.
Yes.
New place of posting, this L, lady social education officer.
Yes.
So there I was serving There was no break at all, my lord, right from the first date of appointment. Your Lordship will kindly have page 45A also, the next page. Your Lordship will kindly see the letter says that I was already regularized by the then Inspector of Schools in 1998, and they have requested the Education Department to accord ex post facto approval of the same. Now, so this ex post facto approval, my lord, never came. And Lordship will kindly see my the letter at page 49. Page 49 is a letter issued by the Director of School Education, Joint Director, to the Joint Director at Meghalaya. Lordship will kind on the subject so and so. I'll just read the points. The incumbent was teaching as an assistant teacher in the said school since 1st March 1998. In the due course of time, she was provincialized on so and so, allowed to continue on ad hoc basis, grade A, against the post so and so. Incumbent was serving as assistant teacher till October 2010. In due course, she appeared for departmental screening test and was transferred from teaching to non-teaching to the LSEO post, my lord. It is found that the service of so-and-so was regularized in grade A based on the order of the additional Director of Public Instruction, White number so-and-so, member number so-and-so. Incumbent has completed her satisfactory service as a teacher for almost 29 years, and her service book is up to date as verified. She was granted the pay for graduate teachers since 1/9/1995 in accordance with the service rules. In fact, since her regulation has been extended up to 21 years, is not promoted elsewhere on higher scale of pay, she has been discharging her duties. So this was an internal letter confirming my service, my regulation, and so on. Our Lordship will kindly see.
Now what happened? What is Annexure 11 then?
Yes, Annexure 11. It seems, my lord, that still the ex post facto approval which was sought for by from the department did not come, and so a letter was given to me on 10th February 2022, saying that the proposal is still under examination.
Not given to you, this is from
Yes,
the
internally,
secretary
yes,
to
yes.
the...
I was given a copy late. I obtained a copy later on. Now thereafter, Lordship,
What happened?
The issue before the cabinet was pending, and Lordship will kindly see page 57. Page 57.
Your name came out in this list.
Yes, yes.
Then what happened? You regularized subsequently.
Yes, the letter said that if I am appointed in the sanctioned post and appointment made before 2007, those have already been approved by the cabinet for regularization, and even the education department. This one, my lord. Then, in view of that, at page 59, Annexure 13, this is my application for VRS, my lord. Way before.
Yes.
1st September 2022. With reference to subject cited above, I have the honor to state that my date of joining an ad hoc sanctioned post was on 1/9/1988. My date of registration as per government order was 1/9/1996. As per the government admissible rules 38A of the so-and-so pension rules, I have completed 34 years of continuous service prior from the date of my joining, and from the date of regularization, I have completed another 26 years. I request you to release me from service as a government employee from 30/10/2022.
So you just got in a quagmire.
Yes.
What is this 61A then?
Lordship?
What is this page 61A? It goes
Yes,
back.
now
Now
61A
what
is-
you've given the date on top, November 21 and below 29, November 22. What do you mean by this?
No,
You're not mindful of the dates. You know.
Type copies were
if this- No. Even then, if you ask my juniors from before, I'm very particular about dates and page and and these little details.
I completely understand, Lordship. In
If
fact,
you don't bother to check with us, that means you're not mindful to interest of your client at all.
I'm very sorry, my lord. This is something which is happening more often than not. Take care of it, Lordship. The letter was of
1989 becomes 1889.
Lordship, the entire. I'm very sorry, my lord. 29 November 2022. Lordship, they informed that.
Okay. Now they said that it's still pending regularization.
Yes.
So what do you want now?
Now thereafter, my lord, yet again I wrote a representation in 6th December after that letter, explaining the entire circumstance that I was already regularized way back by the then inspector.
Then representation, what was it disposed of?
Now against this against the representation at page 62,
yes,
my prayer was again to basically release me on BRS.
Yes.
Now this application was not answered to, my lord, which is why I came with the first round of writ petition, which lordship will find the order at page 66.
Okay, yes.
So the writ petition was closed, my lord, in view of the fact that the representation has been answered.
Okay.
That I am yet to be regularized. Now in the meantime, lordship will kindly come back to page 65. So one day before the order was passed, if I may read, my lord, that sir, the option of VRS is exercised by an employee within 3 months' notice on September 22 under rule FR so and so on condition that she has attained the age of 50 years and is in continuous service for more than 25 years. As per the rule, the concerned department did not comply by giving notice reply to the concerned employee within 3 months and held fulfilling the instance case, the applicant should have been, must be held to have been lawfully retired as notified by her as per rule.
So he resigned?
So in view of this thing, I hereby tender my resignation. This was the language of it.
So he resigned, now you want pension only?
Yes, yes. Now,
yes.
In view of that, they have given
Yes.
me the letter at page 68.
Okay, let's see the letter.
That my resignation is accepted with effect from the 1st of February.
Yes, and then?
So on 2nd of February, I have filed my nomination. It did not, my lord, yield any result.
You lost both ways?
Yes, yes, I lost both ways. So now my prayer is, my lord, that my intention after having 34 years of service was very clear right from September 22. That
Yes,
I
yes,
to
MS NG Shilla, what do you have to say? This is a very sad case.
Yes.
If it's regularized, even if you apply Uma Devi, she's appointed since 1996. Regularized from that
89.
89. You apply that, all the exceptions apply to this petitioner. It's more than 10 years before.
In fact, there are some judgments also that...
No need for judgments. The thing is that only that you've been subjected to some, not trap, it's just the inaction.
Yes,
If they just processed it in normal process, you've been regularized because you already regularized by the whatever that officer
at that point of time.
Yeah, point of time. Only was required was an ex post facto approval.
Yes, now
and you appeared on a regular scale all along. Yes, all the benefits were given.
Departmental thing also I was transferred.
Yes, the only thing, let them compute on last pay drawn of yours and pay pension to you.
Because of resignation, my entire gratuity, nothing. Very.
Lordship, on instructions, my lord, we have categorically stated at paragraph 11 that the proposal made for grant of ex post facto approval to the regularization of the service of the petitioner, the same had to be examined, and in this regard, justification for such proposal was called for as initial appointment of the petitioner was on ad hoc basis. Moreover, the regularization that was granted to the petitioner by order dated 1998 was done so without any authority, as the officers who had granted such regularization were not empowered to issue such orders, Lordship. So thereafter, Lordship, they had to...
now you appointed in 86 first?
89.
89, and then 89, okay.
So they had to go for a cabinet approval, Lordship, whereby certain conditions have been set forth by the cabinet with regard to, again, sanction post number 1, number 2, for only ad hoc appointments made on or before 31st September 2007, subject to rules and regulations, and applies...
I think that this cabinet won't apply to this person. Even if they have been appointed, even if there's no ex post facto approval, even if no approval was sought, the very fact that even though it's not an illegal appointment, at the most irregular appointment, ad hoc appointment, they allowed to continue for years on end. Now the only thing is that how do you reconcile that? Now whether ex post is approval for residence given by competent authority or not, the very fact that is undisputed that she has served for this N number of years, that's all. And so that's the thing, you can't be
now
so...
in April 23, they have regularized also through their...
No, this
because of the resignation, they are not...
Then it should regularize from the period of your, what is that, initial appointment?
Yes.
1996.
So now the government's approval for regulation is...
So
from
now
the date when I was
it's
regularized
been
by
regularized, right?
Yes.
So what remains? So let them calculate on a last pay and gratuity on amount of years.
And in the affidavit is that in view of the rule that resignation entails forfeiture of past service. But my humble submission is, my lord, the circumstances and the compelling reasons and the a little pragmatic approach may be taken in this kind of a matter.
But Lordship,
another case that was here yesterday, you should see the records. Appointment done by the mother to the son.
Yes,
and then the son came for benefit.
But my lord, with regard to the cabinet approval for regularization, it has to be fulfilled by all ad hoc employees, my lord.
No, because that in his case,
have any exemption to anyone.
He's not presented the other case, where exceptions have been made in para 53 of Modi judgment, where those people exercise of regularization who served 10 years, 2006 not been gone into, the respective governments allowed to consider those cases. Now, 1986, 2006, only 20 years. Yes. Number one. Number two, also, even they were appointed, it's not a question of, illegal appointment.
No, it's not.
It's ad hoc appointment, and which was...
Lordship, at Rule 23(1) of the Meghalaya Civil Service Pension Rules 1983, it states that resignation from a post or service, unless allowed to be withdrawn in the public interest by the appointing authority, entails forfeiture of past service, Lordship. So, Lordship, the fact that the petitioner has resigned, Lordship.
Here was the Civil Service Pension Rules. Let's see.
I have.
You referred to that?
Yes.
That's 83 rules.
The 83 rules.
83.
In the
83
affidavit also.
No.
Lordship may have the affidavit.
Yes. Rule?
Rule 23, clause 1. Forfeiture of service on resignation, Lordship.
Oh, yes, she resigned, correct?
Lordship.
Yes, Rule 23. You resigned when?
1st of February 2023, Lordship. That's at Annexure 17 of the petition.
After you regularized or before?
Before, Lordship.
Before,
Lordship.
Before I was regularized by the last cabinet special approval. If Lordship will see
Before you regularized, you resigned?
No. I was already, my contention is that I was already regularized in 1998.
No. Just suppose you just take off the regularized, the formal regularization came after cabinet approval. So before the orders for regularization came, you resigned.
Yes.
That has no meaning. You're an ad hoc, that means according to them, it's still an ad hoc appointee.
Yes, but my contention is that there stand that my approval, my regularization which was done by the inspector of schools was not done by the competent authorities.
No. Forget about that. Now, if you have to forfeit your service, that means you have to say the resignation had no effect. And then...
And in addition, Lordship, Rule 24(1) of the Meghalaya Civil Service Pension Rules also states, an interruption in the service of a government servant entails forfeiture of his past service. Lordship, over here, the petitioner had opted her way out by resignation, Lordship. The list of other employees to have been granted special approval for regularization was forwarded by this office via letter dated 25th of April 2023, Lordship. That is a good nearly 3 months later, in which the petitioner's name was reflected as serial number 1. But by that time, she had already resigned, Lordship. So the petitioner herein has resigned from service on 1st of February 2023 on account of her desire to contest the assembly election. And her resignation was accepted on 2nd of February 2023, as stated earlier. As per the relevant rules quoted noted here and above, there is no question of extending approval to an ad hoc employee who has already resigned from service, as the employee has forfeited her past service and therefore cannot be considered for civil, regularization, Lordship.
I understand on a strict reading of the rule, my lord, I may be in a very back foot. But here, my lord, on this, on this very similar parameter rule, similar circumstances, there are...
You get some authorities then.
At the off, my lord, I have one judgment of the Madras High Court.
Interesting twist.
Madras High Court, where the basic understanding, the judgment basically said that the considering my...
Actually, you didn't have to resign, to contest elections.
No, I applied for VRS.
No, you didn't have to take VRS also.
No, Milo, because if I have to contest, if I have to file my nominations, I cannot be a government employee.
Oh, you're government, okay.
So in view of that, which is why on 1st February till 24 hours before the last date of filing the nomination, I was fighting for my VRS. And only after I filed the writ petition, they...
So if you're rich enough to contest elections, you must be rich enough to support yourself.
No. If Lordship will see my nomination affidavit also, they... not much. But here, my lord, I am praying that my resignation should be treated as a VRS, considering my 34 years of service and in the situation in which I was, so to say, my lord, I was not compelled by anyone, but I was made to resign because of the circumstance. Now,
yes.
Now in September, I wrote them for VRS. They had 3 months' time to either approve it or reject it. As per the rule, if it is...
You can't wind back the clock, because he resigned.
So now the scene is, my lord, the thing is that my prayer is to kindly have a little more pragmatic approach. And
you come from authorities, yes. You'll examine also, it's interesting. Yes, just after 1 week for the hearing. So then you're up against...
On this very same issue, there is one judgment I found today morning only, my lord. Same rule, that unless I get appointed in somewhere, some other thing.
For counting a past service?
Yes, they basically said that considering the Madras...
Is that service standing for elections?
No, I'm trying to... In this matter, what happened is that the person, because of ill health, he resigned. And the pension was not granted to him on view of the resignation. The same rule, the rule in Tamil Nadu is parameter to the rule.
The exception was carved out.
Yes,
we'll look at that later. You bring it, yes.
It should be treated as a VRS.
Much obliged, Lordship.
Obliged, Lordship.
28.
After 1 week, none appears for the petitioner.
30.
What are parties? A Pradhan on the voice.
Is that customs a bit?
Yes, how much money are you going to give?
Well, I'll bring for some time on today. I've received instruction, but they are again retreating the same stand that they are not liable to pay.
See, the order date 24/4. With pressures, only give him 60 lakhs. Otherwise, if I will give 1 last chance, you'll make it out of the court. You pay 60 lakhs, or go and appeal. Simple as that. There's nothing left to argue.
Just some more time. 1 week or 10 days.
It is already delayed.
Very delayed.
Yes.
All the clients think of Mr. Dasgupta, an effective lawyer. Even after this order of the court is there also, still he can't extract the money from you. Okay, after we'll have it after 2 weeks as a final. Take this down. By order dated 24/4/2024, this court observed that the only...
No order will be required. I'll argue on the next matter.
Okay. This matter for 2 weeks, final opportunity to Dr. M. Bozia receive specific instructions finish on the payment of the on sufficient instructions. Otherwise, we'll record the order.
32.
Yes. Yes, MS Ivanian. Matter still going on. What is the problem?
Well, only problem, my lord, this was a contract for deep tubewell, my lord. And because he could not do it properly, so we had to cancel the contract.
No, but then
and
what
we have
happened to the
blacklisted him
contract?
also. Though there is no stay out of my lord, the department is still little
If it's
apprehensive.
order,
that-
then why should you need it? Let it come tomorrow then. As the Senior Counsel available, this is matter tomorrow supplementary list. Maybe we can finish it up also if it's available.
Yes. 33.
The entire matter. Yes.
May I please, Your Lordship. Lordship, this is a matter for two date of birth, my lord, recorded in my service record, my lord. May I please, Lordship. I was appointed in the year 1998, my lord, as motor mechanic. After my appointment, the respondent authorities asked me to submit the school certificate. During that time, my lord, I was
What?
Yes, my lord. During that time, my lord, when I was appointed, I was only passed out from the school, class 7 pass out, my lord. But I have not take my school certificate. After appointment, I went to the school and requested the school authority to issue the certificate, class 7 pass certificate. Thereafter, I have submitted the same to the respondent authorities for recording of my actual and correct date of birth in my service record. And accordingly, the same was recorded as 24th January 1967. Before that, in bracket, it is written as 1964, only the year, my lord. That is an admitted fact. The respondent authorities also admitted that fact, my lord, in their counter affidavit, that I have submitted the school certificate and there is a 2 date of birth. And with regard to the recording of 2 date of birth, my lord, I have made a specific plea in my writ petition, but on that, the state respondents, the respondent authorities are silent on that. There is no reply to that. Why there is 2 date of birth, recording of 2 date of birth. Thereafter, my lord, in my entire service career, the respondent authorities had not issued any notice, neither they have raised the issue of recording of 2 date of birth. All of a sudden, in the year 2022, in the month of May, they serve a notice to me, notice dated 10/5/2022 at Annexure 6, my lord. At Annexure 6, my lord. At page 27, my lord. There is the notice for superannuation pension, my lord. In that notice, my lord, may I read, my lord? As per service record, your date of birth is 1964 and enlisted on 1st March 1988 as per SR Rule 8 bracket 2, A of the Meghalaya FR and SR Rule 1984. Your date of superannuation from government service after attaining 58 years of age will be on 3rd 30/06/2022, my lord. Thereafter, my lord, the impugn order passed, my lord. I have retired, prematurely retired from the service, my lord. Immediately, I have approached the respondent authorities and filed a representation, my lord, stating my grievances, but they failed to, they have not received the same, my representation. And accordingly, they have communicated to me that the same was referred to the Lok Adalat for settlement of the issue. And accordingly, in the month of July, my lord, on 25th July 2023, the Lok Adalat has issued a notice to me calling the petitioner before the Lok Adalat to settle the issue. But the issue was not settled in the Lok Adalat since I have not agreed upon their settlement, and hence the instant writ petition, my lord. The notice of Lok Adalat at page 39, my lord, Annexure 14. My lord, thereafter, my lord, the respondent authorities had pleaded on one aspect, my lord, that at the fake end of service, the date of birth cannot be altered or changed, which is they have stated through one in their affidavit at FRSR rule. But the same principle, my lord, same principle, the doctrine of estoppel is applied to the respondent, the employer, my lord. they also cannot seek for alteration or change of date of birth, my lord.
But here it's written 1964.
Yes, my lord.
This is recorded in your, this biodata annexure 7
Yes,
is
my
from
lord.
where?
Yes, my lord, from the service record, my lord. From the service record. And in their affidavit, my lord, at the affidavit filed by the state respondent, they have also, that is not denied, my lord. They have accepted, it's an admitted position. It's an admitted fact, my lord.
No, it's enter as what in the time? 64, 67?
Yes, my lord.
Enter the 64.
My lord, 64 is only written as only the year 1964. My actual and correct date of birth is recorded
You see,
as...
it happens in these cases sometimes.
Yes, my lord.
I understand why this thing happened.
Yes, my lord.
They always have this time official date of birth and real date of birth.
My lord, maybe.
Doesn't happen like that. It happens all the time.
My lord,
all people, we have some people who've been working, 70 years old, because their date of birth entered service, they were 30 years old, but shown as 18 years old.
My lord.
So this is what happened here. I think your poor petitioner, when he entered, he said like 64, but there is written 3 years concession been given.
My lord, may I please, your lordship? May I please, lordship?
Okay, we'll go on the law.
Yes,
but factually this is what happens. That is why 2 days are given.
My lord, maybe, my lordship is very correct, maybe these things happen. My lord, the school certificate which I have submitted, that is also an admitted fact, they have admitted. But only on their contention is, the respondent's contention is, my lord, that...
now the only thing is that you were not aware that it's entered 67. Now where do you get this record from?
My lord,
the 64. Where do you get this, that biodata from?
My lord, after the issuing notice, my lord.
Then you got the record.
My lord, when after the notice of 10 May 2022, he approached the department. Then he seeks some inquiry, then he get the report, the biodata, my lord. And my service ID card, my lord, time and again, the respondent authorities had issued. In all the service ID cards.
That's as per your submission.
My lord, that is also a fact which needs to be appreciated, my lord. The respondent, the employer, is a duty bound. They are the custodian of the service record, my lord. They are in the higher duty, is a responsibility to maintain the service record, my lord. It's not in my custody.
No, when you entered service, they give this date, 64 and 67.
My lord, that is the confusion. My lord, then on the aspect, on the specific averment, the 2 date of birth, they are silent on that. They have not stated anything on that. That meaning thereby they have admission, my lord, on their part. Why there is 2 date of birth? Then that benefit should goes to.
What about this verification rule annexure 1 to the affidavit?
Annexure 1, my lord. Yes, my lord.
At 64.
Yes, my lord. State respondent, annexure 1, my lord. That is the verification role, my lord.
Then?
Yes, my lord.
This was filled at what time? This is the time entry of service.
After entering into service, my lord. That is, my lord, that is after entering into the service, my lord.
Which year was this document?
My lord?
Which year was the document generated?
My lord, it is...
This is 878.
My lord...
33? What is this in the seal?
My lord, it's...
88?
It is 88, my lord.
Then?
Yes, my lord, 88. My lord, I have submitted my school certificate. That is also an admitted fact. They have admitted that fact. Only within condition...
Where the judgment says school certificate
yes,
is...
my lord. I have relied on judgment, my lord. If my lord allows me...
Yeah, the latest judgment.
Yes, latest judgment, my lord. 2022, volume 6.
Another one also, I think.
211, my lord. My lord, at para... At para 23, my lord, page 220, my lord. May I read, my lord?
No, where's our judgment? The school certificate is right upon. There's a judgment that school certificate is the, is the document that can be relied upon for determining date of birth. Where's that judgment? 224 judgment, I think.
That is
you get it. This one's well known.
Yes, ma'am.
That the unilateral correction.
Yes, my lord.
You get that book. Also, you also, if you can produce also records
my lord,
of the service book.
That is in the custody of
yes,
the...
of course.
Yes, my lord. I'll get
yes,
that judgment.
Matters heard in part. Stop. Mr. Injishalla, the senior government advocate is directed to produce the record service book of the petitioner. Mr. S. sounds to obtain authority to look for authorities. See, there's a judgment. You've not read it.
My
I
lord,
can't
that
offhand,
doesn't-
I'm not good about citations.
My lord, I have not get that judgment. Only this judgment of our Honorable Chief Justice of India on this judgment. On the aspect of the doctrine of estoppel.
No,
that is
not
of-
good
and the
with
custodian
It's a
there.
question of what will be the correct document to ascertain the date of birth from which your case can be founded.
My lord.
That's all.
I'll get it.
So if the discrepancy is in entry of the date of birth by the official authorities and unilaterally maybe try to correct it later on while offering you an option of hearing, then maybe they'll have to re-examine the matter, that's all.
Correct. My lord.
Simple as that.
I'll get it. My 2024 judgment, I'll get it.
I don't know, 24, 23, but...
I'll get it. My lord.
Yes.
Yes, my lord.
Much obliged, Lordship.
And your pleasure.